Good morning. This is the Colorado Oil and Gas Conservation Commission. Happy February. It is February 1st, 2023. It seems strange to me, but maybe that's just me. We will initiate our proceedings today with a roll call to authorize our existence.
Thank you, Mr. Chair. Commissioner Ackerman,
Here.
Commissioner Bowe, Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. That's quorum. Good to see everybody. Welcome to the COGCC business meeting on February 1st. We will start with commissioner comments. This is a time in which commissioners can provide comments, perspective about the work they're doing, et cetera, for the good of the cause. Any commissioner comments this morning? Seeing none, we will roll into general public comments. We had one person sign up for public comment. We encourage folks to sign up and provide us with perspective about the work that we're doing. The person that signed up today is Edward Ingvey. So we would, if he's with us, bring him to the panel and we will provide him with 3 minutes to provide public comment.
Okay, I think I heard my name, but I was getting promoted and it kind of cut out.
No, you are recognized and you have the floor. Great to see you.
Okay, my name is Ed Ingvey and I own and operate Renegade Oil and Gas Company, and I've been doing so for in excess of 35 years as a small independent operator out here in the DJ Basin. Some of you commissioners know that, some of you don't, who are new. I come to you today very frustrated again. Oxy, Anadarko, Kerr-McGee, Western Gas, whatever you want to call them, is at it again. Large parts of their Wattenberg gas gathering infrastructure, which is relied on by people like myself and other small legacy well producers, is being shut down and permanently abandoned. This is despite repeated requests by producers using that infrastructure to sit down and explore options and keeping those pipelines usable. This includes offers of the producers to pay for upgrades, take over and maintain those pipelines, or find third-party gatherers that are interested in taking over those assets. But we've gotten nothing. It's exactly the same pattern as the Third Creek gathering system, but maybe on a smaller scale. Third Creek impacted about 500 wells. This latest event on a significant lateral impacts about 30 wells. The Wattenberg system, unlike Third Creek, though, is still being operated by Western Gas, a subsidiary of Oxy, in areas where they produce themselves. So it's unlike Third Creek to where they abandon the whole thing. They're just abandoning portions of it. The event will certainly increase the state's orphaned well problem. Once again, it's the same pattern as before. When is the Oil and Gas Commission going to interject themselves into these issues? I've been screaming about this situation for years and have gotten almost no traction from either the Oil and Gas Commission itself or the staff. It would certainly be nice if someone out there became interested in preventing orphaned wells as opposed to coming up with a plan once they happen. It almost seems as if there's a political agenda to eliminate all legacy well and small operators like myself in favor of large producers. This seems especially true looking at the makeup of the regulatory bodies. How is it that Oxy or Anadarko personnel were basically given a sabbatical to serve as an oil and gas commissioner and develop rules that crush small parties? How is it that Oxy employees are the industry representative on the orphaned well enterprise? The company responsible for creation of the most orphaned wells in the state is given a seat at the table to develop new regulatory oversight for that part of our industry. This is an insult and an embarrassment, especially to operators like myself. Needs to be pointed out that Oxy owns the historical railroad land grant acreage, and elimination of the legacy wells and operators like me allow them to consolidate their land position and give them effective control for future development of that huge acreage swath. It also needs to be stated how they've collected tens of millions of dollars of royalties when the area was first developed by leasing their minerals to other parties within that land grant corridor and are now leaving the state to clean it up after they have profited. Shame on Anadarko, shame on Oxy, shame on the Oil and Gas Commission. I call on the commission to immediately interject themselves into investigating, in particular, the large producer midstream companies' operating practices in the state and how they might be leveraging their monopoly power to enhance their land positions and to the detriment of small producers and the citizens of Colorado. Something's very fishy going on here, which has been allowed to occur for years. We need to stop the creation of orphan wells, not just an avenue for addressing them and help pay for them after the fact. As always, I would like to make myself available for a deeper dive into this issue. So if the staff or commission at some point in the future desires. Thank you.
Mr. Ingve, what, pray tell, do you believe the commission has jurisdiction over third-party private property issues relative to pipelines and infrastructure that you failed to accord yourself? If you could answer that question, that would be helpful.
It's a good question. I know legally there is probably some ambiguity there. But I think
no. Actually, I don't think there's any ambiguity there. I believe that the issues you're dealing with are third-party private property rights issues. And I do not understand what, if any, relative jurisdictional authority the commission has with regard to private property rights and pipelines and issues that you're complaining about.
At the state level, they operate as a monopoly. They've purchased these existing lines that generally were operated by smaller parties and put them in their bag, basically, and now are closing them down. It's been incredibly frustrating. Like I said, we've had positions where I've been 3 feet from getting a tie-in on an old Third Creek producer to put it to the Wattenberg system. And we made, and it used to be tied to that Wattenberg system. At one time, it was removed about 25 years ago from the Wattenberg and placed on Third Creek. We've had dozens of attempted contacts with Anadarko personnel or Western Gas personnel to say, hey, can we move this? Can we move this over? Can we move this over? And they've been completely thwarted or rejected. I believe that you guys have a role as overseers to the prevention of orphaned wells. Is it not? I mean, this is critical for these legacy wells to stay around. If you just throw up your hands and say, well, we don't have a right here, well, then you're going to have another parade of orphaned wells that are coming on. Like I said, I think these large companies are leveraging their midstream infrastructures, in this case, that they had acquired, not that they originally had built themselves, and I believe are using it to try to squeeze out the legacy well people, especially in Anadarko's position where you have the land grant acreage on top of that, to consolidate their acreage position. I mean, they're on all sides of the equation here. And like I said, I think they're leaving the Oil and Gas Commission in the state of Colorado holding the bag with the orphan wells that they're creating. And you're right, there might be, it might not be a legal issue. It might be more of a soft pressure issue. It might be a political pressure issue. I ask you, Mr. Robbins, have you ever contacted Anadarko and asked them about this and say, hey, isn't there a way that you could help some of these small producers out to try to get some of their wells moved over? It just feels like it goes on deaf ears, and I'm getting people that just throw up their hands and basically say, well, I don't know what we can do here. It's not our issue.
This commissioner is not throwing up his hands. He's just stating the obvious that, this board is not the board for us to evaluate, some sort of antitrust investigation or lawsuit. And that's what it seems like you're sort of, looking for. I'm not trying to throw cold water on any of the points that you're making. I just, we act based upon our rules and based upon our act. And I'm not sure that I'm able to like go back and look at the Oil and Gas Act or our rules. And I don't find a convenient remedy for us. We generally are not involved in midstream issues. And so I appreciate you coming to us, and I appreciate the frustration totally. But I'm just not sure that there is a avenue that exists within the Oil and Gas Act or this commission for us to be able to act in a manner that tries to satisfy the concerns and the legitimate concerns that you bring to us. And I've heard from you for several years, and I've always been sympathetic to the points that you raise, but I don't know that I have a legitimate ability as a commissioner, or that this board has a legitimate ability as a commission to address the concerns that you raise. So I don't know. I've not said these things before, but I've just felt like that, you need to hear from us, because I feel sympathetic to the points you raise.
Well, I just asked you once again, though, have you gone to a legislative fix? Have you in discussions with anybody out there to see if there isn't a patch that maybe could be applied to the act that could, prior to anything closing? Now closing of infrastructure does fall under the jurisdiction of the commission when it comes to spill and spill responses. And I think that was part of the reason that Third Creek happened so quickly, quite frankly, is they were worried that the legislature was going to impose upon them that they'd have to rip out all their lines again. And I think they were worried about maybe finding historical spills. Now, the Oil and Gas Commission does have oversight on historical spills. As you know, too, I've been very frustrated between yourselves and the PUC. At one time, when I came to you guys at first about this whole issue, you kind of directed me to the PUC. I went to the PUC, and the PUC directed me back to you guys. It's been just incredibly frustrating, and the results and where we stood years and years ago, as you well know, have all come to fruition. We've got hundreds of wells out there that were on the Third Creek system that are now within the orphaned well program.
Yeah. Well, let me do this. I would be happy to sit down and listen relative to your thoughts about legislative solutions. And I appreciate that, because I think that's a little bit of an admission that, right now we're sort of hamstrung in that we don't have abilities to sort of deal with these midstream issues and shutdowns, et cetera. But I will make myself available for sitting down and having a further discussion about solutions legislatively. So thanks for bringing this to our attention. I will, be happy to have a further discussion about making or thinking about legislative solutions, because that if we were to have legislative solutions, then this commission would be in a different place. So other commissioners with questions for Mr. Ingve? AG Davenport, I see you have visualized yourself. Good to see you. Thank you.
Just joining the meeting, Chair, but of course here for questions if you have any. Apologize for interrupting.
No problem.
Apologize for being as well.
No problem. We're having a good discussion with Mr. Ingve about issues that are legitimate, but that are, I think, currently we would agree are outside our control. And I've offered myself up to sit down with Mr. Ingve and have further discussions. Commissioner Cross.
Thank you, Mr. Chair, and thank you, Mr. Ingve, for your public comments today. I just want to say that if you are having a meeting about potential legislative responses to this, I'd like to at least to the extent I can be involved as well, because I do think this is an interesting issue and something we could look at if we can especially minimize things going into the orphan well program.
Well, and I know it was several years back, but I believe it was under a Hickenlooper initiative that he originally passed something for a Orphaned Well Prevention Act, if I recall. And I think we looked at that time, that was way prior to you being involved in the Oil and Gas Commission Director Robbins, or not Director Robbins, but Commissioner Robbins. And that just didn't get any traction either. And I think there was language within that to prevent orphaned wells that did maybe provide an avenue for the Oil and Gas Commission to maybe try to interject themselves. Like I said, I'm not so sure that it's a rule imposition, but I think there's certainly some soft pressure, some political pressure, you know, some public pressure that could be levied here, and maybe get us to where we'd all like to be. I say
Okay.
it's just been incredibly frustrating.
No, I think we'll all agree that the frustration is self-evident, and we appreciate your coming before us and testifying once again. We'll set up a time for a chance to talk, and we'll, further that discussion. So thank you very much.
Okay, thank you.
All right. We've now moved through general public comment. At this time, we have a consent agenda with 2 hearing officer recommendations under Rule 505. Does anybody have questions with regard to consent agenda? Commissioner McGowan.
I think this is my appropriate time for me to bring this up, but I was wondering, for one of the recommended orders, if staff wouldn't mind, for the Schreider stipulated agreement, just giving a little background. This seemed unusual to me. I had not seen yet in front of the commission a situation where some of the wells are put into the orphan well fund and the remaining we're allowing the operator to find some time to transfer the wells, but still waiving the penalty. And so I just would like staff's thoughts on how we got to this place, and just kind of maybe talking through why we think this is the best outcome.
Thank you, Commissioner
Unmute.
McGowan.
I see that we've got AAG Schultz. So if he wants to respond, that would be great.
Sure. Thanks, Commissioner McGowan. Good morning, commissioners. So this is Scott Schultz, and I'm the counsel for COGCC enforcement staff in the Schreider matter. This has been many, I'd say, years in the making. This has been going on for quite some time. Really, this is a very standard stipulated order finding violation, except for those 3 Baca County wells. And you'll see in the footnotes that Schreider and company have had 60 days from when the order was signed to post $36,000 in financial assurance for 3 producing wells to keep those out of the orphan well program. The deadline for that is March 6th. So it's a little bit over a month that they still have to post that. There's roughly, again, there's 11 wells involved. 3 of those are from Baca County, which are producing. The other 8 are in Adams County. Again, it is a very kind of standard stipulated order finding violation, except for the potential for the $36,000 to be posted for these Baca County wells, and then those wells would not be automatically transferred to the orphan well program. Happy to answer any specific questions you have on this.
Thank you. Thank you.
Yeah.
Yeah. So we're waiving the violation because they've had some inadequate financial assurance coverage. They have time to put these 3 get these 3 wells adequately financially assured. And my understanding is they have to transfer them. They don't get to keep them. And I want to make sure that when we say transfer, is this a sale? And if there is a sale, do the proceeds from that have to be used to help offset the costs for the wells that are being put into our orphan well program and to P&A those?
There's no provision that regarding a sale. I don't envision a sale for these. It is possible. The way I see this is currently we have roughly $85,000 in financial assurance for these 11 wells. If if $36,000 in additional financial assurance was posted specifically for these 3 Baca County wells, Schreider will no longer exist after this order finding violation goes through. But they would have the option to transfer these to another operator. In there's a provision that really that's a condition precedent, that the posting of the $36,000 is a condition precedent in order for these wells to be kept out of the orphan well program. So the way I see this is that the state will have an additional $36,000 to deal with these Baca County wells that they wouldn't before this.
Okay. And how long does the operators, can you remind me how long the operator has to figure out a transfer? Is that
Until March 6th.
until
So
March
it's
6th? Okay.
60 days from when the stipulated order finding violation was signed. And that
Okay,
was
and then,
January 5th.
yep, okay. And then when I was watching the video, it appears that there are potentially 2 operators that might be willing to take on these wells. And I just want to understand and make sure that Mr. Schreider is not part of either of these 2 companies.
So Mr. Schreider passed away, I believe, in 2018.
Sorry, his son, the person responsible for these wells.
And that's George Kelly, who I don't believe has any sort of actual relation to Mr. Schreider. Mr. Kelly got involved in this company roughly in 2017, 2018. Mr. Schreider passed away. This operatorship was kind of in the hands of his widow. Mr. Kelly did post an additional $20,000 after Mr. Schreider passed away. It still wasn't enough to deal with Schreider and Company as an operator. The 2 potential operators that are listed in the stipulated order finding violation do involve the operator, Mr. George Kelly.
Sorry, I think I'm struggling with this a little bit. So Mr. Kelly now owns all these wells, is responsible for them, hasn't been paying adequate financial assurance. We're taking on the Adams County wells and putting them into the orphan well fund. We're waiving a violation fee, I think of $70-some thousand. He's posting an additional 36 for these 3 wells in Baca, which will be transferred potentially to a company to which he is involved, to which he will profit. Sorry, I'm just trying to figure out how this, I understand that you guys have worked through this. I'm not trying to question, I am questioning. I get that I'm questioning. And I know that you've worked through this as staff to try to figure out the best way to address the situation, but I think I'm struggling with the fact that this gentleman is still then going to have these 3 producing wells and going to benefit from that.
I understand your consternation, Commissioner McGowan. I do. It's not a perfect agreement. I'll state that. But the way I see this agreement is we either have 8 wells or we have 11 wells going to the orphan well program, and we have the pot of financial surety of $85,000. Either way, either we have 8 wells or we have 11 wells going to the orphan well program. If $36,000 in additional financial assurance are posted for these 3 specific producing Baca wells, those wells will not go straight into the orphan well program. Instead, the state will have an additional $36,000 than what they have right now in financial assurance regarding these 3 Baca County wells. This is no get out of jail free card for these 3 Baca County wells. Those wells, really, it's just a condition precedent to remain out of the orphan well program. So the operator, whoever would be the operator of these 3 Baca County wells, would have to comply with all of the current COGCC rules and regulations. There's no guarantee what would happen to these wells in the future, but I see it as an additional, a little bit, albeit not a lot, a little bit of an additional financial surety for the state that they don't have right now for these 3 wells. So that's the way I see it. I know it's I know it's not perfect. I'm not going to really comment on, the future for these potential these two other operators that these may go to. It could be someone different, but they will have to comply with all of the rules and regulations as any other operator would. So the way I see it is that it gives Mr. Kelly an opportunity to post additional financial assurance provided to the state. The state has a little bit more money for these wells if something goes wrong in the future, and these wells are orphaned. So there's no guarantees on what would happen with these wells in the future. But if that additional $36,000 isn't posted by, a little bit over a month, these will go into the orphan well program.
Thank you. Thanks. I don't know if Mr. Gray has anything he'd like to add or to say that hasn't been discussed, but this commissioner is uncomfortable with this agreement that we've come to.
Commissioner Messner?
Thank you, Mr. Chair. In light of this, and particularly with some of the complexities involved with this, I wonder if we could ask AG Davenport what remedies that this commission may have or decision points as far as addressing this in another manner.
AG Davenport?
Thank you, Chair. In terms of your options, assuming the commission as a whole is not interested in allowing the negotiated resolution in the AOC to go forward today, you can you can decline to approve the AOC and request that the parties, staff, and the operator go back and renegotiate with preferably with some direction from you. That's something the volunteer commission has done before when they're not ready to approve a negotiated resolution. In doing so, I think you have to recognize that one possible outcome is that staff and the operator would not be able to come to a resolution based on your direction, and it may end up in a contested enforcement hearing in front of you. But it is certainly an option for you to choose, and this would have to be a motion and vote of the whole commission, to not allow the AOC to go forward as an order of the commission and direct the staff to go back and renegotiate pursuant to some direction that you provide.
Thank you, AG Davenport. So is one of the options to pull this out of a recommended order at this point and continue this decision to next Wednesday's hearing as we determine next steps on this particular item, or does that direction need to be given today?
I should have mentioned this, but sure, you can continue consideration of this to next week if you need additional time to decide what kind of direction you'd like to provide to staff and in renegotiating an AOC.
So understanding that, I would move to continue this particular recommended order to next week to determine next steps by the commission, or next steps by the commission, sorry.
We have a motion. Do we have a second? And then I'll recognize you, Mr. Gray. You don't need to raise both hands.
Second.
Motion and a second. Before we go into commissioner questions or deliberation on the motion, I would recognize Mr. Gray.
Thank you, Commissioner Robbins. Commissioner McGowan asked me for some comments, and I didn't get a chance to address her invitation. And so I'd like to do that now. I'd like to add a little context from Schreider's perspective. By way of introduction, my name is Zach Gray. I'm legal counsel for Schreider and Company. Mr. Kelly is the principal of Schreider and Company, and he inherited, took over this company and its assets 2016, 2017, simultaneously with the death of Mr. Schreider, who was the primary principal of the company. At that time, Schreider and Company had no email address or contact information that the commission could find him at. He had a severe case of dementia. Schreider and Company was not filing Form 9s. They were completely a ghost operator. Mr. Kelly came in, corrected all those things, is now in strong communication with the commission. And the primary reason why these wells are not up to snuff with the regulatory requirements is because they're on the same line that Mr. Ingiv was talking about in your general comments. These are Third Creek wells. Schreider has no strong cash flow to bring the wells into compliance. If these wells could be plugged into the Third Creek line or some line close to that, there'd be cash flow, and these wells would be able to be brought into compliance with the regulations, and we wouldn't be here today. And so extremely frustrating to hear about how it'd be a bad thing that some of these wells that are not tied to the Third Creek line would survive with Mr. Kelly, who has shown nothing but an intent to comply with regulations so long as his company can cash flow on the assets that it has. So, you know, I understand the motion, I understand the second. If I could, before the vote, I'd like to request a sidebar with Assistant Attorney General Schultz, just to discuss this briefly with him.
I don't know that that's necessary, Mr. Gray. Appreciate the point. All we're doing is kicking this out for a week, and that actually would give you that opportunity for sidebar during that interim. Would you disagree?
No, so long as we're just saying we'll take this back up in a week. I don't need my sidebar now.
Everybody in agreement? All right, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? You have an opportunity now to discuss this with AAG Davenport. Other concerns, questions with regard to consent agenda?
I don't want to belabor the point on this case, but I guess I would ask the commission for a little direction. To me, and I don't want to open negotiations up to the public here, but the only other option is for those 3 Baca County wells to also go into the orphan well program, you know, immediately. Part of the wrinkle and part of the negotiations that Mr. Gray and I had is to just simply provide Mr. Kelly the opportunity to not have these 3 wells go into the orphan well program. You know, we're trying not to have producing wells go there. You know, there's this little window of opportunity. Again, it's just a little over 30 days for them to post that additional financial assurance. If that financial assurance is not posted by March 6th, then this would be, again, a standard stipulated order finding violation where Schreider and Company no longer exists as an operator in Colorado, and all of those wells would go to the orphan well program. And regardless of, again, the 8 or the 11 wells, roughly the $85,000 in financial assurance will go to the orphan well team. Again, it's not adequate at all to cover what will be required. But I just want to provide you a little context. Is staff and myself are seeking to provide this narrow window of opportunity to allow these 3 producing wells to not go to the orphan well program. You know, again, it's a very narrow window, and it provides the state with additional financial assurance that they don't currently have. I'm happy to negotiate further with Mr. Gray, but again, the only other option would be to include those 3 Baca County wells in a stipulated order finding violation, and they would all just directly go to the orphan well program with no opportunity to post additional financial assurance, and keep those 3 producing Baca County wells out of the orphan well program. Again, there's a chance that, I think probably a pretty good chance that the additional $36,000 is not posted and all of these wells do go to the orphan well program. But the wrinkle in this stipulated order finding violation was that window of opportunity to provide the state with additional financial assurance for these 3 producing wells.
Commissioner Messner.
Thank you, Mr. Chair. AG Schultz, I appreciate your thoughts, but the motion was simply to move any kind of direction to staff for a week so that the commission has an opportunity to evaluate this AOC or this agreement and provide direction should the commission choose to, and or allow it to stand next week. So there's no decision point or no direction to be given at this point. It's actually to be determined next week. And so that's the decision that the commission has made at this point.
Understood. Thanks.
Commissioner McGowan.
Thank you, Mr. Chair. So from this commissioner, it might be helpful to understand why it has taken so long for this operator to come forward and remedy the situation that they were in. Just because someone dies and you inherit something doesn't mean you're not responsible for figuring out what the rules are to come into compliance, which hasn't happened since 2016 or 2017. And so it would be helpful to understand how we got here. What I'm struggling with is an operator who's not been in compliance, and it seems odd that we're allowing this operator to give up wells that they're responsible for to go into the orphan well fund while being able to keep 3 viable wells while we take care of those orphan wells that they can't take care of, and still be the owner of those wells that continue to operate. And I might be the only commissioner who has an issue with this or is struggling with this, and that's okay. That's okay. That's how this works, and this is how the deliberative process works. And I'm trying to also really honor the work that staff has done. This seems very odd to me. And so that's just my thoughts. And I understand that I might be the only commissioner who thinks this, and that's okay.
All right. I mean, with that, I believe as Commissioner Messner summarized, this has been continued. There will be opportunities for Mr. Gray to discuss this further with Mr. Schultz. Mr. Davenport is also available. I think that there's nothing further for us to. Mr. Gray, I'm sorry, you keep raising your hand. What more do you like to add to this equation?
Thank you. I just wanted to clarify. Commissioner McGowan asked for a little clarification on the situation, and I'd like to provide that. It'll be 30 seconds if that's acceptable.
Go ahead.
Thank you. So think of these wells as 2 different types. There's 8 in Adams County on the Third Creek line that we have not been able to plug into since it was shut down. The other 3 are producing in Baca County. And so it's not that he refuses to come into compliance. It's that the status of the gas line for those 8 wells is such that he cannot put them online to make money to come into compliance. And so we're saying, take those. Our hands are up in the air on the Third Creek stuff, but let us operate the wells that are producing because we'll have the funds to keep those in compliance.
Okay, thank you very much for that additional editorial. This matter is continued. We've, I think, approved consent, so let's move on. All right, at this point, we need to bring up docket 2205-00108. Let's take 5 minutes, get everybody up on the panel on that docket, and then we will return at 9:48. All gathering back again. Okay, Mr. Pichardo, before we get to you in the next docket matter, I think I misspoke. I'm not sure that we approved consent. We still need a motion to approve the rest of consent agenda. but not including the matter that we continued. Do we have a motion?
So moved.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Okay, we now will move to our next agenda item, 2205-00108. This involves an oil and gas development plan. The applicant is BNL Enterprise Incorporated, and Mr. Pashala is the attorney for the applicant. You are recognized.
Thank you, Mr. Chair. I'm just looking to see, yes, Mr. Condrat is there and Ms. Gross. Great. Thank you. Good morning, Mr. Chair and Commissioners. My name is Joe Pershala with Wellborn, Sullivan, Meck and Tooley, and I'm here on behalf of the applicant BNL Enterprise on its oil and gas development plan in the application docket number 2205-00108. With me here today are Peter Condrat, Chief Operating Officer of BNL, and Andrea Gross, the project lead of upstream petroleum management that has been working with BNL on these locations. BNL's application before you today involves helium development in Los Animas County, Colorado. The application requests that the commission approve the BBB 2860 oil and gas development plan. It includes approximately 480 acres covering portions of sections 33 and 34 in Township 28 South, Range 60 West. And the two locations are the BBB 33 Southeast Southeast 2860 pad and the BBB 34 Southwest Northwest 2860 pad. Each pad has one vertical well, which would explore for and produce helium gas from the Lions Formation. BNL has a fee oil and gas lease with rights to produce helium from the mineral owner, which is BBB Ranch. It's also the surface owner of the location on which these pads are being proposed. With respect to spacing, these lands are not subject to any commission spacing orders and are therefore subject to the statewide spacing rules under Rule 401. BNL is proposing to develop the application lands on a leasehold basis subject to Rule 401B. Specifically, the Lions Formation is less than 2,500 feet in depth. The wells will be located more than 200 feet from a lease line, and there are no other existing or permitted wells in the Lions Formation that are within 300 feet of these proposed wells. Therefore, no spacing is required and spacing is not being applied for. The locations, as I mentioned, are on fee surface. It's rural rangeland. BNL has worked cooperatively with the surface owner, has a surface use agreement, which does memorialize the parties' agreement to the locations and the access roads. The locations do not meet any of the criteria under Rule 304 B2B. Therefore, an alternative location analysis was not required and was not conducted. As you will hear during BNL's presentation, BNL worked closely with Colorado Parks and Wildlife regarding a pipeline takeaway route in the manner in which it crosses the ephemeral Tempest Creek. With respect to relevant local government, that is Los Animas County, it does not regulate the siting of oil and gas locations. BNL is consulted with the county regarding the locations and there's been no objection from the county. The county does, however, require building permits for these locations. Those permits are currently pending the approval of this OGDP application. With respect to notice, BNL has given proper notice pursuant to Rule 504 and Rule 303. No petitions or protests have been received. On January 26, 2023, the director issued the director recommendation, which does recommend approval of the application. Based on the application, the director recommendation, and the presentation that'll be given to you today, BNL believes that the application satisfies the Conservation Act, and commission rules, and BNL respectfully requests that the commission adopt the director's recommendation to approve this application. And with that, I would turn it over to Mr. Condrat and Ms. Gross, who will provide you with a presentation on the development plan, the locations, as well as answer any of your questions. Thank you very much.
Thank you. Mr. Condrat.
Good morning, Mr. Chair, Commissioners. Thank you for your opportunity to present this helium project and your attention to the matter. I am the Chief Operating Officer of BNL, the operator of record. I had come from extensive experience in helium operations. I'm familiar with the geology, the drilling, the completion, the production, and the marketing of helium. During any time you guys have any questions in that manner, please let me know. We do have a presentation file. How best do we share that? Do I take over the screen or?
Do you have an opportunity for share screen?
Mr. Conrad?
Yes, I do. Is that okay, Mimi?
Yes.
Ms. Larson? Are you guys able to see my screen?
Okay, we can see your screen. It's not in presentation mode, so we see all your other slides to the left. If you want to go up to the left-hand corner up there and turn it into presentation mode, then we'll only see the points you want us to see at each point.
Yeah, I have it in presentation mode and it's on a different screen. Sorry for this. Almost there, sorry.
Yeah, no, take your time.
Do you guys see my screen now?
We do. We see a narrative in Word.
But you don't see the presentation?
We do not.
Mm-hmm.
Always be careful what you share.
Yes, sir.
Ms. Larson, if you could visualize yourself, you're really good at helping folks get to the proper screen sharing mode.
So, Mr. Conrad, I would recommend closing your Word document.
Yes, ma'am.
And then if you go back to your PowerPoint, it just, if possible, have that be the only screen that is open on your desktop. I would close out all other applications.
Okay.
And if you'd like, you could also just email it to me and I could share the screen as well.
Yeah, I apologize. I'm not sure why you guys don't see my screen properly.
Okay, so we see the COGCC map or Google Earth right now.
Yeah. If I may,
There you go. We see that. And so then if you just want to put it in
let's see, when I click that, it goes to a different screen. Is it possible to share this presentation like this manner here? You can see everything. Okay.
Yeah, we're able to see. Yeah, it says presentation to COGCC. I think you're in pretty good format. I mean, we can see that Blue Star Helium.
Okay, well, thank you. Again, so, I just wanted to run through our operations out here. If you have any questions, Andrea will take over the end of the presentation to kind of review the wells in more detail. Happy to answer any questions, of course. Again, Blue Star Helium, we're our parent company of BNL is Blue Star Helium, which is an Australian stock exchange company. We're a Colorado-based team with head office in Australia. We have extensive experience helium, oil and gas permitting, drilling, depletion production, geology, marketing of helium. This is an incredible opportunity for the state of Colorado. Helium is it's hard to get economic accumulations of helium, let alone produce them. Helium has a lot of unique properties where it is in high demand and low supply right now. We have an exciting helium project in Los Animas County. I know I've ran through these slides with you guys before. Happy to answer any questions at the end or during the presentation here. So I think it's important to recognize that helium is not a fossil fuel. It's an inert noble gas. The area that we are at in Los Animas County has been sparsely drilled, but every well that's been drilled out there, there are no hydrocarbon in any appreciable amounts. We have a inert gas system with noble gases that include helium, nitrogen, and CO2. Here's some of the properties of helium and oil and gas. I'm just going to keep going through these. If you guys have any questions, go back to it. The geology sets up for it. You've got an extensive elevated Precambrian basement that went through radioactive decay, and then you had late stage tertiary activities, intrusions Pluton stocks, such as Spanish peaks that brought helium to the surface or higher to the surface and being trapped in structures. This is kind of where we sit and where Los Animas County sits in all of the helium accumulations recognized. And what this shows is the helium percentages based on the circle and the depths to those. And it's important to note that in Colorado, in Los Animas County, in southeastern Colorado, you have some of the highest helium concentrations in the world. And we're on our way to hopefully produce those. We use a very small rig. We use water well rigs. These are just truck mounted rigs that have a very small footprint. We use air drilling. There is no mud system. There's no closed loop system. We've worked with the state of Colorado and COGCC to set up a way for us for cuttings containment and removal. Get an idea of what our facilities may look like. This is an example of the rig right here. So I know I flew through those, but I was on purpose because I know you guys have seen those before. Andrea, if you want to start talking about our first well, the BBB 33.
Thank you, Peter. As mentioned, my name is Andrea Gross. I work for Upstream Petroleum Management. I've been helping BNL permit their locations within Colorado. As Joe stated earlier, the BBB 33 Southeast 2860 is for one vertical helium well using statewide spacing. It's located in a very rural area near Thatcher, Colorado, which is in Los Animas County. The BBB ranch is an active cattle ranch. The parcel on which the BBBs are located are being used for cattle grazing. The BBB 33 is anticipated to be approximately 1.2 acres of disturbance, which they will reduce down to 0.2 acres after interim reclamation. Pete, could you go to the next slide, please? This location did not trigger the required alternative location analysis. It's not within 2,000 feet of any sensitive receptor. Next slide. As you can see on this map, there will be the need for some new disturbance for an access road, but then it will utilize county roads out to a state highway. The other location within this OGDP is the BBB 34 Southwest Northwest 2860, also on lands owned by the BBB ranch being used for cattle grazing. It will also be approximately 1.2 acres and then be reduced to 0.3 acres after interim reclamation. This location also did not trigger the requirement of an ALA. This location will utilize the same access road as the BBB 33 and then use existing county roads in the area out to the state highway. This OGDP did trigger a CPW consultation under Rule 309E2A, which states which states a proposed oil and gas location or associated new access road, utility or pipeline corridor falls within high priority habitat, a state park or a state wildlife area. As you can see in this map, the Tempest Creek runs through Thatcher, Colorado. However, there is an existing county road that already crosses Tempest Creek. Tempest Creek has been designated as a no surface occupancy for aquatic native species. County Road 76.5 does cross Tempest Creek right now, and there's an existing culvert there. Through BNL's consultations with CPW, they offered two solutions in order to ensure that the creek would not be disturbed. The preferred method would be to continue the installation of the pipeline within the county road right of way and be installed on top of the Tempest Creek, on top of that existing culvert. If that proves to not be feasible, they've also agreed that they would bore under Tempest Creek outside of the NSO buffer. Both methods would ensure that the creek bed and flow would not be disturbed. And CPW gave us approval for both options. Next slide. Within our OGDP, BNL has proposed many best management practices that would ensure the safety of the environment and those within this area. Like Peter said, these locations will not produce any hydrocarbons. They do not require hydraulic fracturing. They intend to use a rig liner and secondary containment to protect any groundwater. They've cited their locations to be not within 2,000 feet of any permanent water structure or surface water. There is an ephemeral stream about 350 feet from one of the working path surfaces. It is typically dry, and we had a wildlife biologist go out to the areas and do a wildlife reconnaissance visit. He did not observe any ordinary high water mark in that ephemeral stream. They will use stormwater control such as silt fence, straw wattles, mulching and seeding soil stockpiles, and secondary containment of any fuel tanks that may be temporarily on location. Outside of the NSO, there are no high priority habitats within the area. Like I said, we did have a wildlife biologist visit both of the sites. He did not witness or see any habitat that would be suitable for any sensitive or threatened species.
And that concludes our presentation.
Great, thank you. At this point, I believe commissioners have an opportunity for questions for the panel. Are there questions for the panel? And Mr. Pashala, seeing you revisualized yourself, are you, did you conclude, does that conclude your presentation?
It does. I was just making myself available visually if there were any questions for council.
Yeah, got it. Commissioner Ackerman.
Thank you, Mr. Chair. I don't have much of a line of inquiry on this application. Appreciate the work with CPW to work with the native aquatic species habitat. I did just have a bit of a random question on the interim reclamation. It talks about a seed mix being approved by CPW, but also by the Colorado State Land Board. And that was the only mention of the land board that I found in this application. And I wonder if that might have been a cut and paste error from previous development on maybe state land board property. And I'm not sure that you would need a state land board approval for a seed mix on this fee title. I know I'm catching you a little cold with that, but that might be something worth taking a look at.
Thank you, Commissioner Ackerman. And yes, I do apologize. All of our locations thus far have been on state land. And I do believe it was a carryover from that. State land board does not have any jurisdiction, nor would we need their approval. It will be with work in consideration with CPW as well as the surface owner. Thank you for bringing that to our attention.
You bet, thank you. And so I don't know if that requires any modification in the motion or anything, but I would suggest that you strike state land board approval there. The other comment there, and I brought this up with staff just for future knowledge, but there's a little bit of a misstatement in there that it'll be fenced with wildlife friendly fencing to keep ungulates out of the location. But there are many species of wildlife that are ungulates, and wildlife friendly fencing is intended to allow wildlife to pass. And so I think we mean to keep livestock out, but I'm not absolutely positive that that's the case. So that could be clarified as well. And those are really the only comments that I have, Mr. Chair.
Anyone from the panel desire to clarify the fencing issue?
Yes, it would be most likely livestock fencing if the surface owner would like us to do so.
Thank you. Yeah, that's what I suspected.
All right, any further questions for the panel? All right, does any commissioner desire to make a motion?
Move for approval of the application.
Do we need to reflect any of the Commissioner Ackerman comments there? Commissioner, AG Mercer.
Thank you. Yes, I would, if it's the commission's pleasure to include Commissioner Ackerman's amendments, I would suggest modifying the motion to also include modifying the application to remove state land board approval of the seed mix, and perhaps provide direction to the applicant and staff to clarify or correct the wildlife fencing portion.
Commissioner Cross, are you comfortable with said friendly amendments?
I am comfortable with that and would amend the motion as such.
Commissioner Messner, okay with that second?
Second.
All right. We have a motion with friendly amendments, a second with friendly amendments. Any further discussion? Seeing none, all those in favor of said motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Thank you, Mr. Priscilla, Mr. Condrat, and Ms. Gross. We appreciate your being with us. Your motion has been approved. Go forth and produce helium.
Thank
Thank you
you.
very much.
Thank you.
Okay, commissioners, I need to take about a 10-minute break to deal with the matter. So let's return at 10:21, and then we will take up the next matter on our agenda. Okay, welcome back, everybody. Next on our agenda is docket 2206-00164. This involves an oil and gas development plan application. The applicant is CCRP Operating. Let's bring to the, we already have to the panel, Ms. Wazelinski. Good morning. Before we get started, I want to note that in my review of this matter from the pleadings, I, as one commissioner, note that this is raising sort of a novel issue with regard to correlative rights and potential underdevelopment of the DSU. It has 4 wells and 1,300 and some odd acres. Engineering staff has raised a concern that this is not efficient development. And I'm not saying that's right, wrong, or otherwise, Ms. Wazelinski, I'm just raising the issue. And I wonder if it doesn't make sense for us to allow us an opportunity to, so this is kind of a new issue for us. And I'm a little concerned about raising a new legal issue to us in a discrete application, as opposed to giving the commissioners an opportunity to perhaps have an executive session and understand the issues one way or another. I guess what I'm really going with is this right for us to review today? Or is this something that we should continue for a week or so to allow staff and the applicant to have further dialogue about it? I'm not trying to truncate any rights that you have, Ms. Wazelinski, at all. I'm just like raising something before it becomes an issue before us. So I see that Director Murphy has visualized herself. I'm definitely going to give you an opportunity to speak, Ms. Wazelinski. Let's hear from Director Murphy first, and then we'll hear from you, Ms. Wazelinski, and we can like chart forth the proper go forward path.
Thank you, Chair, and thanks for your patience. I think that making sure we understand the interrelationship between correlative rights and a unit and the statutory requirements about not overdeveloping is a very important legal question, and is one that we need to understand exactly how we are going to interpret and apply those provisions. I've seen underdeveloped units before that have harmed mineral owners, and that has given rise to my concerns about this application, and recognizing that I think the applicant has put forward arguments or reasons why it's also okay. And I won't speak for Ms. Wazelinski. She's eminently capable. So,
Ms. Wazelinski, sorry to put you on kind of a spot here, but would you like to weigh in on this initial discussion before we open the docket?
Yes, thank you, Chair Robbins and Director Murphy. CCRP is fully prepared to address the correlative rights and proposed 4 wells within the unit today. We've put a lot of time preparing, and I've got a lot of information and statutory citations, and I'm happy to field questions on the drainage issues and potential development or underdevelopment. And so we are prepared to go forward. I think you'll find that our presentation fully addresses the questions raised in the engineering review. And if you would, we would recommend moving forward, allowing us to present, having a dialogue, and allowing this to move forward today, because I do think we could provide a good education and a good response to those issues raised in the engineering review.
Okay. I mean, I'm comfortable moving forward knowing that I've sort of set the bar that if we're uncomfortable, I mean, we need to be comfortable making decisions at the right time. And so if we hear from you and we still suggest that, we might need an executive session because these are novel issues, or continuance to sort of understand it, note that that's not like pre-indicating in a decision. It's just, we want to get this right. Is that fair, Ms. Weslinky?
Understood. Yes.
Okay. All right. Well, then let's call up the docket 2206-00164. Ms. Weslinky, you and your panel are recognized. Do you have your folks up for us to hear from them?
We do. And I just want to clarify, Jason Maxey was supposed to speak before us. So while I don't see him here, I'm wondering if he's available and will be providing his 5 minutes of comments.
Ms. Larson, were you able to identify Mr. Maxey?
Yes, Mr. Maxey is now in the meeting.
Wonderful.
Okay, then let's proceed with our normal course of procedure, and let's raise Mr. Maxey to the panel, and we will hear from Mr. Maxey, who is the director of the oil, I don't know exactly what to call it, the oil and gas department in Weld County. Great to see you again there, Mr. Maxey. You have the floor.
Thank you, Chair Robbins, and thank you, Commission. I appreciate the few minutes, as always. It's been a little while since we've been here. It's can't believe it's already February, so thank you for a few minutes of your time this morning to speak on the CCRP Sumac application. Understanding that there are some other items that you all will be discussing this morning that do not necessarily deal with surface type of items. I will, of course, keep my comments to the 1041 WOGLA process that Weld County has in place, and just some high-level comments for this one in particular. Weld County comments were submitted back in November of last year, and they should be reflected on your Form 2A. Weld County has gone through the complete 1041 WOGLA process for this location, and we do have an assigned approved WOGLA permit number in place. We held our pre-app meeting for this close to a year ago, actually. It's amazing how time flies, but that was back on February 9th of 2022. And this meeting did include not only CCRP, the applicant, and oil and gas energy staff from Weld County, but it did also include the COGCC staff representation, along with CPW staff representation. CCRP did submit their application to Weld County on May 19th of last year. And within that application, they proposed and Weld County staff analyzed 3 alternative locations, which were reviewed and discussed in full detail, not only with staff, but also in front of our hearing officer. We did go through our normal process regarding referral requests that were sent out to multiple agencies June 30th. Excuse me. Responses were received from internal Weld County departments such as Environmental Health, Public Works, our Planning Department, along with external referral agencies, including yourself, the COGCC, the CDPHE, and then also one more additional Weld County Department of Office of Emergency Management. We did not receive any referral responses back from the fire protection districts or the school districts, even though we sent them out to those agencies. However, it is noteworthy to say that through the Office of Emergency Management, our emergency action plan, which is a part of every single WOGLA, was approved, and that document should be a part of the application in front of you as well. One other item to note is, since this location is so close to the Wyoming border, we did also send referral requests out to the Laramie County Planning Department as well. We did not receive any questions or any applications for participation in our hearing process. We held our hearing on August 18th, and at that hearing, the hearing officer did find that they needed a little bit more information to be compliant with Weld County code requirements. And so there was actually a continuation of this permit. Excuse me. So that was continued from September 1st. And it looks like our final order was issued on September 13th and published in the Greeley Tribune on September 16th. From a land use perspective, Weld County staff believes that this is a good location. It is close to other oil and gas development, although it's not immediately adjacent to it, but it is close. And again, it's a very rural area, and there's no receptors from Weld County's standpoint that would preclude this development moving forward. So with all that being said, Weld County would support the approval of this permit from the state side of things, and would be happy to answer any questions that I maybe could help with. Thank you.
Any questions for Mr. Maxey? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Maxey, for being here. Just a quick question. In the Weld County review process, is there any consideration for encouraging operators to use existing sites versus new disturbance?
Thank you, Commissioner Messner. And the answer in general is yes. When we're looking at alternative locations, both our staff, when we're reviewing the application, as well as the hearing officer, do ask the applicant about cumulative impacts. And when we look at cumulative impacts, part of that is also considering new surface disturbance or being able to co-locate or locate adjacent to an existing pad. And so in general, yes, our process, we do consider those, and we get the applicant not only on record at our hearings, but that should also be a part of their written testimony within their application that they submit about those considerations.
So in this particular application, how did Weld County handle the applicant's decision to develop new disturbance versus utilizing existing disturbance?
How did we handle that? Meaning maybe what was part of the discussion?
What was your decision process? Because I think we've got an application that's proposing new disturbance in lieu of utilizing existing locations that could be technically feasible to utilize.
And that is the case. There are, like I said earlier, there are existing locations. I'm going to say, based on the information that I have on my screen right now, we do have 2 locations that are somewhat close to the west. One of them, in fact, the location that's furthest to the west, actually has an older Weld County permit on it. The one that is in between the two, the existing WOGLA and the proposed location, does not have any type of Weld County permit on it from the records that I see. I can confirm with you, Commissioner, that we did ask about the co-location or co-mingling of those facilities, basically on some additional, or excuse me, on the existing disturbance that's already out there. I'm getting a Teams message right now, so I was not a part of those discussions, but I do know that our staff asked about those, and I can see, let's see, it looks like one of the alternates would be used as part of the development, but not from the location to drill wells, at least in the information that we received. So I can commit to you that we did ask them those questions. The reasoning behind it, that the applicant chose to move forward with the preferred location that's in front of you today, I would probably leave up to their testimony today, since again, we heard ours quite a few months ago, and I don't recall the exact reasons why they didn't choose to do that.
Okay, thank you, Mr. Maxey.
You're welcome.
Any further questions for Mr. Maxey? All right, Mr. Maxey, thank you very much for being with us. We always appreciate Weld County's perspective on applications within its jurisdiction. So thanks for being with us.
Thank you very much.
If further questions arise, I know how to find you. All right, Ms. Wazelinski, I believe you have the floor.
Thank you. And thank you, Mr. Maxey, and thank you, Chair Robin and commissioners. If we may please allow us just a few minutes to share our PowerPoint, and then I'll get started. Wonderful. Well, good morning, commissioners. Again, my name is Kelsey Waselinki with Jost Energy Law. And with Jamie Jost, we represent CCRP operating in the Sumac 126513 OGDP before you today in docket 2206-00164. Next slide, please. I'll start with just a brief summary of the relief requested in the Sumac OGDP, which is to establish an approximate 1,349 acre drilling and spacing unit and approve 3 new horizontal wells and 1 refile horizontal well for the Niobrara, Fort Hays, Codell, and Carlisle formations, to approve the approximate 1,353.3 acre Sumac 126513 OGDP for the development of a total of 4 horizontal wells within the requested drilling and spacing unit, and to provide that the subject wells shall be located on the new Sumac 126513 pad and the existing True Ranch Fee 2326 East pad, and approve the Form 2A for the new Sumac 126513 pad. Before I turn it over to the CCRP team, I would like to highlight just a few key aspects of this OGDP. The new location is in Weld County, just south of the Wyoming border, and CCRP has an approved 1041 WOGLA siting permit for the Sumac 126513 pad. No public comments were received throughout the WOGLA and COGCC permitting processes, and no formal petitions were filed. The location triggers just 1 ALA criteria. It's entirely within the pronghorn and mule deer high priority habitats. CCRP consulted with CPW and conducted an alternative location analysis as part of the WOGLA and COGCC processes. CCRP will walk you through the ALA today in detail, which includes 3 alternative locations. And I'll summarize 2 of these locations briefly now, as we did receive a few commissioner questions on alternatives number 2 and 3, which CCRP again will address in detail later in the presentation. Alternative number 2 is referred to as the Grindberg State Line Federal Pad, which is in the northwest of section 24, the upper left corner within the blue box defining the application lands on the map shown here. We received a commissioner question regarding the proposed use of the Grindberg pad in the original Sumac OGDP application. CCRP's OGDP application cites the existing Grindberg pad and the drilled but not completed Grindberg State Line Federal well. This well was drilled by another operator and later acquired by CCRP. As stated in the OGDP application, CCRP does not intend to produce the Grindberg well and will either convert this well to an injection well or plug, abandon, and reclaim the Grindberg pad. CCRP agrees to a condition of approval as outlined as COA number 3 in the director recommendation that commits to a time certain to either commence plugging operations of the Grindberg well or submit an injection well permit. Alternative number 3 is the existing True Ranch Fee 2326 East pad, which is included in the Sumac OGDP because it will have 1 horizontal well drilled within the proposed Sumac drilling and spacing unit. I highlight these for you now at the outset of the presentation so that as the CCRP team addresses your questions on the alternative locations, it's clear that alternative number 2 is the Grindberg pad in section 24 that's subject to COA number 3, and alternative number 3 is the existing True Ranch pad in section 23 that's included in the OGDP. And finally, in consideration of current and future proposed development plans, surface owner requests, surface and subsurface constraints, and the BMPs and COAs agreed to on the Form 2A, including the avoidance of operations in the pronghorn and mule deer winter seasons, the proposed Sumac 126513 pad is the most protective location to avoid and then minimize and then mitigate potential adverse impacts to public health, safety, welfare, the environment, and wildlife resources, while efficiently developing the mineral asset. And we respectfully request approval of the Sumac OGDP and associated drilling and spacing unit. And with that, I will turn it over to Jesse Martin with CCRP to continue the presentation.
Next slide, please. Good morning, Mr. Chair and Commissioners. My name is Jesse Martin. I am the Vice President of Land for CCRP Operating Inc. and will be presenting the majority of the slides today. I don't feel a need to spend much time in this one. It merely outlines the order which we will be presenting. Next slide. CCRP Operating is headquartered in Lakewood, Colorado, with operations in the DJ Basin in both Wyoming and Colorado. I'll be presenting for CCRP along with Nathaniel Korsevsky, CCRP Operations Manager, and panelist Joe Schultz, Business and Engineering Manager with RPG Resources. Next. The Sumac OGDP timeline. We started this permitting process back in March 2022. The OGDP was filed in June and subsequently amended in August. In September, we received Weld County's approval on our WOGLA. And since September, we've passed completeness review, the hearing notice, the comment period, and petition deadline with no comments or petitions received. Last week, we received the director's recommendation for approval, which brings us here today. Next. The anticipated phases of development. This slide is a good visual display of our estimated timing and duration for each phase of the operations. Note the construction, drilling, and completion activities are all anticipated to occur outside the winter season for both pronghorn and mule deer high priority habitat timing restrictions. Next. The Sumac location overview. This proposed location is situated along the Wyoming-Colorado border, as shown with the white dotted line running east-west across the center of the right map. This location disturbance will be 8.03 acres and 4.01 acres after interim reclamation. The access road to location originates from a Laramie County road known as Chalk Bluffs Road and continues south into Colorado. Only the last half-mile road will be constructed and/or improved to access location. A surface use agreement has been executed with the surface owner, True Ranches, LLC. Next. The True Ranch surface ownership. The slide shows the expansive footprint of the surface owner, True Ranches LLC, the entire access road, the proposed Sumac pad, and all viable alternative locations are also located on their surface. During our initial meeting, CCRP met on site with True Ranches to find a suitable well site location, which was ultimately agreed upon to be the proposed Sumac. The Sumac pad minimizes disturbance with its proximity to an existing road and level topography. True Ranches has executed a surface use agreement for the Sumac pad and access road and is supportive of CCRP's development of such. In response to Commissioner question on why the landowner preferred a third location built in their property, the landowner also owns a mineral interest in adjacent yet to be developed spacing units. They want to see an efficient and optimized pattern of development that will ultimately result in more productivity wells and prevent waste of the resource. The Sumac pad location lends itself to the subsurface efficiency while also avoiding sensitive surface receptors and abiding by the protections in the wildlife mitigation plan. Next slide. The Sumac siting analysis. The Sumac pad is in a remote rural setting with primary land use being agricultural rangeland. The nearest RVU is True Ranch headquarters, which is located almost 3/4 of a mile away. No schools, childcare centers, or designated outdoor activity areas are within several miles of location. Only the 1202D high priority habitat was triggered in the ALA, which I'll address in the next slide. Ultimately, the Sumac pad is cited to minimize disturbance while efficiently developing the spacing unit. Next slide. Siting analysis rule 1202D high priority habitat. This slide gives a visual on how expansive the HPH lands are and how they cannot be physically avoided when developing this DSU. The Sumac and how all alternate locations are inside the COGCC rule 1202D, pronghorn winter concentration area and mule deer severe winter range high priority habitats. CCRP consulted with the Colorado Parks and Wildlife on site in March of 2022 and again virtually in January 2023. The agreed upon wildlife mitigation plan requires both mitigation fees based on the acreage disturbance and the avoidance of winter season, December 1st through April 30th. The proposed 2023 HPH designations have no impact on the above. Next slide. So the wildlife protections in the Form 2A. These are some of the key items from a mitigation plan. Pad construction, drilling, and completion operations will be limited to the 7 months between May 1st and November 30th of each year. If construction, drilling, or completion activities cannot be avoided between May 1st and November 30th due to unforeseen circumstances, CCRP will provide notice to CPW and COGCC staff and pay the additional compensatory mitigation fees as set forth in the Wildlife Mitigation Plan. Now, bullet point number 3 is direct from the CPW's wildlife assessment. While CPW prefers the proposed pad be located on one of the existing pads, Alt 2 or Alt 3, given CCRP's avoidance measures, avoiding winter season with new work, the minimization, various BMPs such as migratory bird surveys, and mitigation, payment of direct and indirect mitigation dollars to CPW to offset their impact, CPW believes this OGDP is sufficiently protective of wildlife and the effective HPHs. So ultimately, CPW did conclude the proposed operations on the sumac pad will protect wildlife high priority habitat. Next slide. The alternative location analysis. This slide shows the location of the sumac pad in relation to the other 3 alternative locations. Alt 1 is located on the southern end of the DSU. This location would require construction of approximately 2 miles of road, resulting in extensive surface disturbance and is not supported by CCRP or the surface owner. Alt 2 is also referred to as the Grinberg pad. This pad will be utilized for placing water storage tanks, which are required for the completion of the new sumac wells. CCRP is currently exploring the potential to convert the Grinberg well to an injection well, and CCRP fully agrees with the director's recommendation, condition of approval number 3, which requires this pad to either be reclaimed within 1 year of commencement of construction of the sumac pad or to initiate permit to convert the well, the Grinberg well, to an injection well. In response to another commissioner question as to why there was one drilled but not yet completed well in this site, the Grinberg well was drilled by the previous operator, Gadeco. I cannot give an explanation as to why they did not complete it at that time, but it was later acquired by CCRP as part of a larger acquisition and will not be completed by CCRP as a producer, but will either be fully plugged and reclaimed or converted to an injection well. Alt 3 is also referred to as the True Ranch 23 pad. From this pad, one well will be drilled into the western side of the sumac DSU and an additional well into its own DSU. CCRP asserts and COGCC staff agrees this pad is located too far west to develop the east side of the sumac DSU. Lastly is the sumac pad, which is positioned to minimize the surface disturbance by locating adjacent to an existing road and on gentle topography, and also minimize downhole complexity with the reduction of the step outs by locating centrally to the east-west boundaries of the DSU. I'll turn the next slide over to Nathaniel Korsevsky, our operations manager, to go into more detail on the directional step out complexity.
My name is Nate Korsevsky. As Jesse mentioned, I'm the operations manager for CCRP. This slide was added to illustrate the downhole complexity we're concerned with if using alternate locations 2 or 3 versus using the sumac location. One thing to keep in mind when we consider the surface locations, it's important to also consider the downhole implications. These can have impact on the surface for the life of the wells and will impact our ability to efficiently develop the minerals. If we compare the step outs from alternate location 2, the Grindberg, to the easternmost sumac well, this is a step out of about 3,700 feet. Drilling that same easternmost well from alternate location 3 would be an even greater step out of a full mile. Following up on the commissioner's question regarding why the proposed additional well at the True Ranch doesn't have the same workover complications explained for the Grinberg site, the step out on the proposed easternmost well from the True Ranch 23 pad is only about 1,890 feet. Which is still about half of the step out we would see from alternate location 2, the Grindberg, to the eastern side of the sumac DSU. And that 1,890 feet is still within our experience for not causing drilling or production complications. Maximum step out of less than about 2,000 feet is ideal to avoid downhole issues and to ensure we efficiently develop the unit and don't strand any minerals, which the centrally located sumac pad provides. Further to that, for example, on the drilling side, we have less drill bit control along step out and more torque and drag. This can lead to more frequent corrections to the steering, and it will make it more difficult to land in the target formation and get to the final depth. This ultimately results in a more tortuous final wellbore, which can make it more difficult to get casing to bottom and issues on the production side later. We would also have higher fluid circulating pressures, adding more potential for drilling, mud, and cement losses. If we have difficulty landing the well as planned entirely in zone as a result of this, or getting it drilled and cased all the way to the bottom, this could strand some minerals, as well as lengthen the duration of the operation. On the production side, what we're looking at here with a higher angle well or a tortuous wellbore shape that resulted from directional steering corrections during drilling, we would see more downhole equipment failures for the life of the well. We've seen this with our closest existing offset well pads. That's what these pictures are here, where we have two wells, one with an ideal step out of less than about 1,500 feet. That's the well on the right there, bottom right, and one with a 3,400 foot plus step out. The well with a significant step out suffers twice as many downhole failures, requiring workover interventions, which, as you guys know, involves heavy equipment and increased activity and traffic in the area. Ultimate recovery from the unconventional reservoir may also be improved into reaching the economic threshold sooner, which could further strand some minerals. So any use of a location other than the sumac would lead to additional impacts, not just during initial drilling and completion, but as I've shown here, for the life of the wells, and could hamper efficient development, possibly stranding a portion of the minerals on that east side of the unit. I'll turn it back over to Jesse for the next slide.
All right, cumulative impacts. Similar to slide number 6, this is a visual display of estimated timing and duration of the construction, the operations, and interim reclamation of the Sumac and True Ranch 23, also known as the Alt-3 well pads. In addition, if water disposal is found to not be a viable option on the Grinberg or Alt-2 well pad, it will undergo final reclamation, returning 9.3 acres to rangeland use, which abides by condition of approval number 3 in the director's recommendation. Note again that all activities are anticipated to occur outside the HPH timing restrictions for both pronghorn and mule deer. Next slide. The next several slides, 15 through 18, are the best management practices for each phase of operations. This first phase being the construction. Pursuant to the director's recommendation of COA number 1, if CCRP desires to increase the allowable noise level at the location per Rule 423D, CCRP will obtain and approve Form 4 sundry notice with an updated noise mitigation plan that includes the ambient noise monitoring results prior to the commencement of new construction. During this initial phase of construction, all topsoil will be salvaged and stormwater protection measures will be in place. Disturbed lands and topsoil stockpile will be stabilized and seeded with a CPW approved seed mix. Next slide. The drilling phase. During this phase, the cuttings will be separated and disposed in a permitted facility. Odor will be minimized by utilization of a closed loop system with type 3 OBM. Light pollution will be reduced by angling rig lighting downward. Potential soil contamination from spills will be prevented by placing the rig on an impermeable liner, and fugitive dust emissions will be curtailed by watering the access road as needed. Next slide. The completion and flowback phase. In addition to the BMPs in place during the drilling phase, for the completion and flowback phase of operations, CCRP will reduce emissions by utilization of EPA Tier 4 dual fuel engines. Proppant will be transported via containerized sandbox technology, and frac operations will be halted if sustained wind speeds exceed 25 miles per hour. Midstream infrastructure for natural gas gathering and sales will be on location and operational before the wells commence production. CCRP has already engaged the midstream company for extending their line to the Sumac pad. Pursuant to the director's recommendation, COA number 2, Within 30 days after the well completion operations have concluded, CCRP will provide an as-built survey of the total new disturbance acreage for both location and access road via Form 4 sundry notice. Next slide. The final phase of operations will be the interim reclamation and production phase. During this time, CCRP will perform interim reclamation on the sumac pad, returning just over 4 acres to productive rangeland. Stormwater mitigation measures will be in place and properly maintained. Potential leaks and spills will be curtailed by CCRP's automation and regular performance of scheduled inspection and maintenance of equipment and secondary containment. Light pollution will be minimized by use of warm colors, timers, and motion sensors. Again, CCRP is in agreement with COA number 3 from the director's recommendation, where the Grinberg or Alt 2 location will either be fully reclaimed and or converted to an injection well. In response to another commissioner's question on CCRP's current use of injection well, all flowback and produced water is going to the commercial disposal C8, operated by NGL Energy Partners in Grover, which is approximately 37 miles away. This is the closest injection well in the area and where CCRP currently sends all of its water from its existing wells. NGL Energy Partners has not disclosed an estimated longevity, but as stated, they are not expecting any injection issues in the foreseeable future. At this point, I'll turn it back over to Kelsey to conclude our presentation.
Thank you, Mr. Martin. Before I address the remaining commissioner questions, I'll reiterate just a few highlights again of the SUMAC 126513 OGDP. The OGDP complies with COGCC rules and the Act by first avoiding potential impacts by siting outside of sensitive receptors and committing to conducting operations outside of the winter season for pronghorn and mule deer. The OGDP also minimizes and mitigates potential impacts through the agreed upon COAs and BMPs on the Form 2A, including the Wildlife Mitigation Plan. CCRP complied with all applicable notice requirements, and no questions or objections from the notice parties were received, no public comments were submitted, and no interventions or petitions were filed. The director recommends approval of the OGDP, and CCRP agrees to the 3 conditions of approval outlined in the director recommendation. Weld County again approved the WOGLA in September of 2022 through the robust 1041 WOGLA process. The requested spacing unit prevents waste, protects correlative rights, and avoids the drilling of unnecessary wells, and ensures the efficient development of the hydrocarbon resource. And finally, a net of over 5.9 acres will be returned to surface owners for productive use after the sumac pad and road are interim reclaimed. An additional 9.3 acres will be reclaimed if water disposal is not viable on the Grindberg State Line fed well pad. Next slide. Before I conclude on this slide that summarizes the requested relief, I want to address an issue raised in the director recommendation on the proposed drilling and spacing unit density of 4 wells, and also a commissioner question on the use of existing locations. COGCC engineering staff questioned whether the 4 proposed horizontal wells will result in efficient development. And the director recommendation acknowledges that the production data is limited in this area and that it's difficult to anticipate how many wells will optimize the efficient development of this acreage. The director recommendation also acknowledges that the requested drilling and spacing unit meets the requirements of the Act. When evaluating a drilling and spacing unit, the Oil and Gas Act provides in section 116(1)(a) that to prevent or assist in preventing waste, to avoid the drilling of unnecessary wells, or to protect correlative rights, the commission may establish 1 or more drilling units of a specified size and shape covering any pool or portion of a pool. Section 116(2) provides that no drilling unit shall be smaller than the maximum area that can be efficiently and economically drained by 1 well. And section 116(4) provides that the commission may decrease or increase the size of the drilling unit or permit additional wells to be drilled within the established unit in order to prevent or assist in preventing waste, or to avoid the drilling of unnecessary wells, or to protect correlative rights. CCRP's technical engineering testimony shows that the requested 4 horizontal wells will not drain beyond the boundaries of the requested unit, will result in efficient and economic development, will prevent waste, and will protect correlative rights. Just north of the OGDP in Wyoming, it is common to develop 3 to 4 wells in a similar size spacing unit. If after drilling the 4 requested wells in the drilling and spacing unit, CCRP determines that additional wells will prevent waste, protect correlative rights, and more efficiently develop the resource, CCRP will come back and amend the drilling and spacing unit and OGDP to add wells, which CCRP acknowledges in the OGDP application. I will also reiterate that no mineral owner within the unit has questioned or objected to the proposed development plan or raised any correlative rights issues. The Oil and Gas Act states that correlative rights means that each owner and producer in a common pool or source of supply shall have an equal opportunity to obtain and produce his just and equitable share underlying the pool. It would frankly harm correlative rights to develop this resource inefficiently or to drill unnecessary wells. And the proposed development of the Sumac pad proposes methodical and efficient development that will prevent waste. We also received a commissioner question on how disturbing a third location supports the avoid, minimize, mitigate hierarchy in the commission's rules compared to the use of existing locations. When looking at the proposed development of approximately 1,349 acres of minerals from the Sumac pad, it's important to consider the definition of waste in the Oil and Gas Act. Importantly, waste does not include the non-production of oil or gas from a formation if necessary to protect public health, safety, welfare, the environment, or wildlife resources. Here, while CPW would prefer CCRP to minimize surface disturbance through the use of an existing location, the final CPW assessment of this OGDP contains a clear representation that the Sumac pad is sufficiently protective of wildlife and the affected high priority habitats in consideration of CCRP's commitment to avoid operations in the winter season, coupled with the BMPs and the wildlife mitigation plan. Further, if an existing location is utilized to develop the proposed spacing unit, CCRP would not be able to develop the minerals in the eastern half of the unit, thereby resulting in waste. The Act also defines waste as the locating, spacing, drilling, equipping, operating, or producing of any oil or gas well or wells in a manner that causes or tends to cause reduction in quantity of oil or gas ultimately recoverable from a pool under prudent and proper operations. In short, because the Sumac pad will still be protective of wildlife resources and use of an existing location will create waste, the Sumac OGDP complies with the Commission's rules and the Act, and CCRP respectfully requests your approval today. And this now does conclude our presentation. We have a team of subject matter experts with us, and we are open for questions.
Okay, great. Thank you very much for the presentation. Commissioners, I wonder if, again, I appreciate the presentation, but I wonder if we should either have staff at this point provide some perspective with regard to the correlative rights issue, or we could go into executive session. Ms. Murphy, Director Murphy, do you want to provide perspective having heard the presentation from the applicant?
I can provide some short comments and also acknowledge that this is a legal question and I don't practice law anymore and I've forgotten how to, very intentionally. To me, I think it's important to understand the spacing considerations as Ms. Wozelinski clearly articulated, but foundational to those points is also making sure that we are protecting correlative rights. And in a space where we see underspacing, I get concerned that we're going to end up diluting mineral interest ownership. And we've had experience with this in other arenas where you create a unit larger than what is proposed to be developed at that point in time. And I think that creates concern for me that a mineral owner is being drained of their minerals and then but not receiving the total compensation for it. Those are being paid across the unit. And so that to me is a challenge of correlative rights, is it really is a balancing act. And looking at efficient development, right? We don't want too many wells, but too few presents other problems as well. And so that's a fairly high level maybe comment about what the concerns are. And, you know, I welcome questions or ongoing dialogue about it.
All right. Let's open it up for commissioner questions at this point for either Ms. Wozelinski, Director Murphy, the rest of the panel. And if any commissioner believes it would be prudent to have an executive session, we can do that too. Commissioner McGowan.
Thank you, Mr. Chair. And I don't know if I need executive session yet, maybe to ask some questions and then decide if we need to do so. So I'm trying to understand the Grinberg site in particular. And I understand that a previous owner did the original bore, and it's not producing, it was not drilled. Wasn't drilled, just it wasn't completed. And so so are those minerals in that, is it an adjacent DSU? Those will not be developed by this operator, even though that pad and that well is owned by this operator?
Jesse, would you like to take that?
Yes, I can answer that. It's a good question, Commissioner. The Grinberg location is in the same DSU as our sumac, and the minerals underlying the Grinberg will be produced and pooled as part of the sumac DSU and production.
Okay. So I'm trying to understand maybe this also idea of the difficulty of the step out and workovers and risk. I feel like we've had other operators in their OGDB proposals have step outs without similar problems. So is this the ability to access equipment and the type of equipment? Is it the specific geology involved here? And I'm wondering if you could talk about that a little bit and why we wouldn't be able to use that Grinberg site.
This is Nate. I can address that. So just because other operators do it doesn't mean that they don't have issues with it. And on the drilling side, for example, when you put a well out there that steps out 3,700 feet, right, you're laying at an angle of about 45 degrees. And so it significantly lengthens the amount of that angle we have to drill, and steering becomes more problematic. So what happens oftentimes is as they start getting farther out there, we could be up and down on target, and target means the Codell formation we're trying to target, right? So we may come in low, we may come in high. And anytime you're low or high in formation, for example, you could be outside of formation, which means you've missed the ability to effectively produce that formation. So there's that risk, right? If it's a straight, easy to drill wellbore, there's a much higher chance of success that you're going to follow your drill plan and stay right in the target formation in zone longer, right? So there's always that risk. Also, by creating that additional torque drag and corrections during steering, right, you create, what we call dog leg in the well, which is the waviness of the well, right? That can lead to equipment issues when you're producing it, which is why you need more workovers. And anytime we do a workover, right, we shut the well in, we're not producing it. So you're leaving minerals down there that you hope come back when you turn the well back on. But it's generally better to keep a well online 24/7, not just for the surface impacts, but to make sure you're effectively capturing and accelerating that mineral production. So what I was trying to show in that slide is that I don't want to give you a specific number on how many times it would fail or what the nature of the problems would be, because we just don't know right until we're there. All I can show you is that in our closest DSU 4 miles to the east, we have this exact example, right, where one step out is kind of a normal 1,500 feet, and that well fails 1.5 times a year, but then the one that's twice as far away fails twice as often, right? And so there is an impact to us on the ability to produce that well, right? And every time we have a workover, there's a rig we got to put in the area, there's pickup trucks, there's traffic, right? You're in high priority habitats. So the less we can do that, obviously the better it is for dust mitigation, habitat, all of that. So
Okay, thank you. In my understanding, based on this conversation and your testimony, that the proposed sumac site would be an appropriate site to develop more minerals to the east of this DSU, or would that require yet another pad?
This is Jesse. I can answer that question. The sumac pad will develop both the east and the center of the DSU, and the farthest western portion of the DSU will come from an existing pad. And that was the True Ranch 23
Ranch.
pad, also known as the Alt-2, if I remember correctly.
So knowing that that's kind of the plan that you have, why wouldn't the proposal be for the current proposed sumac site plus the development to the east, so that you wouldn't be coming back to drill more wells to capture those minerals also to the east? I think we're trying to figure out how we minimize the number of times that you're in this area, because you are in high priority habitat. And it sounds like you do have some future plans for this area and the minerals.
But let me restate my answer. Maybe I wasn't clear on that, but we do not have plans to build another pad. We believe with this sumac pad, we will fully develop the DSU.
Sorry, so with those 4 wells, you think you will develop the DSU that you've proposed to us, but not to the east, but this pad would be appropriate to develop the minerals to the east. So why wasn't that included in this proposal? Or am I misunderstanding?
Commissioner McGowan, I'm happy to help clarify that. Are you referring to outside of the DSU and adjacent to the east, whether sumac would develop those minerals? Okay, so maybe I'll have Jesse come back to that question as to which I don't believe is the case, and currently not in this plan. And I'm not sure if CCRP even owns the leaseholder mineral interests adjacent to the east of the proposed sumac unit.
Okay,
But
I appreciate that, because I feel like the minerals to the east have been discussed as part of testimony today, but maybe
and I believe, thank you, Commissioner. And I believe when we're referring to minerals to the east, we're talking about the eastern half of the unit, where if we were to use the True Ranch pad or the Grindberg pad, we couldn't reach to the eastern half of the unit and fully develop the acreage.
Okay, thank you. That was misunderstanding what y'all were getting at. Thank
You're
you. So I'm wondering why, given staff's concerns about fully developing the mineral rights under the proposed DSU, in order to minimize impact and not come back and build more wells, the proposal wouldn't just be the total number of wells we feel needed to develop all the mineral rights and not have to come back and drill more wells, because we're also, right, this hierarchy of avoid, minimize, mitigate. If we know that more than 4 wells are needed, we really want to try to have you drill what's necessary up front and not come back and disturb. And so I'm wondering why that's not part of the proposal.
Thank you, Commissioner McGowan, and I'll address this just at the outset. Based on the best available science and, within the technical testimony that CCRP submitted, a density of 4 wells is the most efficient design of this development plan at this time. This is not the core of the DJ Basin. This is a different area. When you look kind of north and in surrounding areas, you'll see 4 wells per formation is fairly common, and efficient and protective of correlative rights. So the point being that it's obviously in CCRP's best interest to most efficiently develop the proposed unit. And if after drilling, 4 wells, it is determined that more acreage could be drained, which again, right now, the science does not support that and would lead to unnecessary wells, which is a violation of the act. CCRP does have the right to come back and amend the OGDP and amend the unit and drill additional wells. And we do realize that would be another occupation of the pad, but CCRP has committed to conducting all operations outside of the winter season to avoid those impacts to mule deer. So really it's looking at the best science and the best data. And we've had no mineral owners raise any concerns with the density here. This is a unique area of the state. And right now it's 4 wells is supported for the unit.
Okay, thank you. I appreciate that, but I feel like we're getting kind of a conflicting message from our staff, which is they're worried that the science or evidence would be that the 4 wells isn't sufficient. So I'm just trying to parse out what we have in front of us. So
sure,
that's
understood.
all I have for now. Thank you.
Sure. Yep. And I think CCRP is very cognizant of drilling unnecessary wells. They've got a real interest in efficient development, and the act mandates it. So that's really where this is going.
I would recognize either Ms. Trask or Ms. Burns, who have both visualized themselves from staff, if they wanted to weigh in on any of the questions that have been asked so far.
Thank you, Chair Robbins. This is Sabrina Trask. I'm the Planning and Permitting Manager at COGCC. I wanted to highlight part of our concern with a couple things. Let me start with the step out question. So looking at our recent submittals from CCRP for well bores, APD submittals for well bores on a different location outside of this OGDP, not associated with this OGDP or these locations at all, is section 27. And if I might share my screen, I can show the map. It might be a little bit easier if I show it rather than try to speak to it.
Go ahead.
Let me know if you can see what appears to be our COGIS interactive GIS map.
Yep, we see it.
Okay. So the green strip along the top is Wyoming. The purple area sort of centered in the screen is the OGDP under consideration right now. Just to the west, in section 22 and section 27, you should see 3 light blue lines. Those are proposed well bores submitted by CCRP for a location in the southeast corner of section 27. I just wanted to note that the step out for this furthest, the westmost well bore appears to be approximately 3,000 feet, which is significantly greater than the step out proposed in the current OGDP application. And so looking at this information, staff sort of has determined or assumes, and that's not a great word, but assumes that if CCRP is able to conduct drilling operations in section 27 that involve a 3,000 foot step out, then we're not sure why they can't do that in section 24 and 25 as well. So that's one question that I don't know that it's been answered. If CCRP is able to answer that question, it might provide a lot of insight about what is being proposed in the SUMAC OGDP. So maybe I'll stop for now. And it looks like Ms. Wazelenki is nodding and might like to give an answer to that.
Thank you, Ms. Trask. Jesse, I believe, is prepared to answer that question.
Yes, that's a good point you brought up. And so in the situation of the well that you were looking at, I got another maps that matches with yours here I'm going off of, but that eastern step out is about 3,000 feet. And in that particular situation, the well pad has previously been permitted through the Vogel and I believe also the OGDP process. The 3,000 foot's not ideal. We're trying to work with what we have. When we apply that same thing to the SUMAC pad, again, trying to work with what we have. If we go to one of the alternate locations, whether it's the True Ranch 23, the Alt 2, or the Grinberg, the Alt 3 pad, just making sure to get those confused there with each other. The step outs are going to be even greater. The Grinberg being a closer pad, we're still going to have a step out of 3,800 feet, if not more, to get to the eastern side of this DSU where the SUMAC pad is going to develop. I think that the technologically feasible part is not an argument that we can make because it's technologically feasible. It comes down to, is it a good idea? It's more workovers, as Nate has pointed out. It would be more traffic back and forth. It's going to be resources left behind because the well is shut in. So although technologically feasible, and as we have proposed on the other pad, it is not an ideal situation and one we try to avoid when possible.
I'll add to that, Jesse, that you'll end up with, from the Grindberg alternate location 2, you would end up with 2 pretty lengthy step outs to access the eastern side of that unit versus that True Ranch pad you were just looking at there really just has the 1 step out.
Commissioner Messner.
Thank you, Mr. Chair. Thank you all for your presentation and providing information and taking our questions. just I guess, a statement first. I mean, it does appear, even after Ms. Wassilinki's explanations, that there's going to be some legal questions that may indicate that this application is not ripe for review at this point, and at a minimum, this commissioner would like a executive session. Having said that, I do have a couple of questions that may get me further along as far as fully understanding the proposal. One of the questions is perhaps a misunderstanding of what CPW has actually indicated in their recommendation. So I would like to ask if Mr. Moret is available, and I don't know as he is, but if I read the recommendation provided by CPW, it pretty clearly indicates that it's even bolded, that based upon these above factors, since CPW is following our high priority habitat recommendations and COGCC guidance, CPW prefers that this proposed WPS be located on one of the existing pads, either alternative 1 or alternative 3. Now, it does go on to say, not in bold, that if this commission decides to pursue the Sumac location, or the operator does, that there may be circumstances that would make it mitigatable. But again, the criteria is first to avoid, then minimize, and where you can't avoid or minimize, to mitigate. And so I'm trying to understand how the applicant is making a showing of avoidance in this situation where there is a technical feasible location, understanding that this is in high priority habitat, 2 different high priority habitats. And so alternative measures need to be taken to avoid, and habitat fragmentation associated with new disturbance and new roads is a significant impact in high priority habitat areas, irregardless of timing restrictions. So maybe help me on that one.
Thank you, Commissioner Mesner. I'm happy to address some of those questions. And you're correct that the CPW assessment did include, a preference for using existing locations. However, does conclude at the end, and I've got it up right here, that we believe this OGDP is sufficiently protective of wildlife and the affected high priority habitats. And that's if the COGCC and or CCRP decide to pursue the proposed Sumac location. And I see Mr. Moret here too, and I'll just make one more point before I perhaps turn it over to him. But I do think it's important to consider the condition of approval number 3, and that is when we're looking at minimizing disturbance, CCRP has committed in a time certain to either fully plug and reclaim that Grindberg pad or put it to a beneficial use of saltwater disposal. And either way, you're going to have avoidance measures. You're going to have, if it's saltwater disposal, you're going to have avoidance of traffic and these long hallways. And as you can see, we're kind of deep in the high priority habitat here. And CCRP is going to an injection well quite a distance away. And so I think it's important to understand that that condition of approval on the Grindberg pad provides some certainty and would consider that to be avoidance. You also need to look, this proposed OGDP has an access road almost entirely within Wyoming. And so CCRP is really trying to do its best on avoidance measures in consultation with CPW, and has committed to avoiding that winter season. And we've seen in prior OGDPs approved by this commission that is really a strong consideration, is that a commitment to avoid the winter season. So
let me ask a follow-up question there before we have Mr. Moret, just so that we understand, or at least I understand, what your argument here is, because you're talking about a disposal well, or potentially the benefits of the disposal well, but associated with that disposal well are additional impacts, correct? I mean, there's additional activity that's occurring in high priority habitats. There's additional truck trips or truck traffic associated with disposal wells. There's additional impacts associated with that. So just turning it into an injection well, in this commissioner's opinion, doesn't necessarily have less impacts associated to wildlife in a high priority habitat, unless that injection well is going to commit to the same timing restrictions as the production well, which it may or may not be able to based on the operations that are occurring or the need for utilizing that injection well. So I'm just trying to understand that one a little bit, how that truly is a benefit. Now, if it's plugged and abandoned, reclaimed, that's a different story, right? But that's different than utilizing it as an injection well. But
Understood.
Mr. Moret, I'd be super curious as to seeing how we're now arguing over your comments and you actually made the comments, what your thoughts are.
Thank you, Commissioner Messner and commissioners and members of the public. For the record, my name is Brandon Moret. I'm a certified wildlife biologist and currently CPW's Northeast Region Energy Liaison. Yeah, so given my comments in the wildlife determination summary, yeah, it is CPW's preference to maintain large tracts of contiguous, unfragmented big game habitats, especially those that are high priority habitats. And the other point that you were getting at, Commissioner Messner, is avoidance of what? That's the question on the table. Are we avoiding just the surface disturbance itself or the season? So we're talking about two different things there. And yeah, it's CPW's point, as is written under the rules under 1202D, we're not trying to have lots of areas where there is a density of oil and gas that exceeds 5 per square mile. And so that was the reasoning behind my comments about preferring an existing pad on the landscape. And yes, CPW prefers the reclamation of one or both of the pads eventually. And so, but at the same time, reclamation, that could take years before COGCC finally approves of such reclamation activities. And CPW does appreciate all the BMPs that CCRP and Ms. Wazlinki have described in their presentations, but if it were up to CPW, obviously we're not an expert in downhole and step outs and all that, but we're focused solely on the surface impacts just for the big game. And especially you have to think about like how this has been a cold winter too. And CPW is working on a pronghorn collar study right now to see, our pronghorn coming out of Wyoming, and especially since this is on the Wyoming border. And so it's CPW's preference to limit the number of existing pads out there and to use existing pads and access roads to the extent possible.
Thank you, Mr. Moret. That's super helpful and clarifying. So I appreciate your being here with us today and providing that insight. So with that, I'm going to shift to kind of the correlative rights issue, the waste issue, the number of wells. And I'm just going to ask to make sure that I understand, because I'm not sure I have an issue with the number of wells being proposed, but at the same time, I need to understand the legal aspects of it, which is why I will ask for an executive session at some point. But I want to understand the notice that's given to mineral rights owners associated with this drilling and spacing unit and whether they're fully informed that what this operator is proposing may or may not provide adequate compensation to them.
Thank you, Commissioner Mesner, and I'm happy to take that. So all working interest, meaning leasehold owners within the proposed unit and unleased owners who own unleased interest within the unit received the completeness notice of the oil and gas development plan, which contained the commission's information sheets on how to provide comment, how to submit, how to contact the operator, detailed information on the proposed development, where the surface location is, where the wells are, in addition to a notice of hearing, which formally noticed the OGDP for hearing and provided a formal petition deadline. They were also noticed, I believe, and Jesse can correct me if I'm wrong, and Mr. Maxey, of course, throughout the WOGLA process in the area. So they've had multiple opportunities and engagement with CCRP to comment. And as of today, there have been no objections raised or questions, frankly, asked about the proposed development. As I stated, this is a unique area of the state, and this type of density being requested is fairly common in this area.
No, and I appreciate that. I mean, I appreciate you went through the standard notice processes that are required by rule. I guess I'm curious, was there any additional information provided to folks that this is kind of an abnormal spacing proposal within this DSU, and that it may or may not be successful in providing what may be customary as far as compensation for their particular mineral rights. Does that make sense what I'm asking?
It does, and I would respectfully disagree that it's abnormal spacing request. I think it's a very standard and quote normal spacing density request again in this area. And so included with the mailing after the OGDP reached completeness was the full drilling and spacing unit application, which again outlined the well density, where the surface location, the formations to be targeted, the subsurface setbacks. So that was noticed at completeness. And again, no objections received from CCRP.
Okay. That's the extent of my questions at this point. Thank you.
Commissioner Ackerman.
Thank you, Mr. Chair. I do have a couple of questions and then maybe a couple of comments as well. And I can't remember who was presenting the slide, but we moved through the slide pretty quickly on the timing. And in the application, I saw that, that drilling was intended to begin in November. The timing stipulations would start December 1, and I couldn't quite see the timeline enough to gain confidence that there was time enough to get there. And so I wonder if you can either pull that up or whoever was talking about that, talk about your confidence level of being able to complete operations on the ground prior to December 1.
Jesse, if you'd like to chat about the timeline, and we're happy to pull up that timeline slide. Justin, I'll send you a slide number here.
I think it's slide number 6 will get you there. There's two that are kind of the same.
Thank you.
Thank you. I appreciate that.
So commissioners, there was 2 slides where we had the timeline on there. This one here with the timing restrictions of the HPH, this is outside of that. So it would be August when we would initiate construction. And then through the drilling and completion phase, we anticipate being done by the end of November, with December 1st being the timing restrictions come back into place.
Gotcha. Yeah, I thought what I saw on here was 28 days. And does that mean that the intent is to begin completion on November 1 because it would take the entirety of the month to do it?
That's not the intent. It's this is not intended to be, I guess, that granular. It's approximately 21 days to start, construction. It could go quicker than that. We could have a rig there sooner. We may drill quicker than 25 days. We're just trying to go more of a worst case scenario. If we put these days in a line, does this work with August 1st? There's also the potential we could be out here before August 1st if all permits are approved and rig availability. This could all happen, months in advance of what we're showing here.
Understood. Thank you so much. And I didn't note any discussion about what if, right? What if you don't get there? Do you just shut down and shut in at whatever stage you're at until after the winter closure period? Is that the intent?
There would be 2 possible outcomes there. One would be depending where you're at in the phase, if it's drilled, not completed, it could be a removal of the equipment and wait till restrictions are lifted before we complete the well. If it's while drilling or while completion, we're not able to just stop that fast. And that's where the wildlife mitigation plan does have a provision, which includes us to gain approval from CPW and from COGCC to move into those stipulation windows with additional compensatory mitigation fees.
Yeah, thank you. I saw that in the mitigation plan. I appreciate you talking about it. Thank you. Switching gears a little bit, I thought I saw in the application that diesel engines would be used, and then I thought I saw in the presentation that they would be potential hybrid engines. Can you clarify your approach there? And I mean for the drill rig.
Yes, I can answer that one as well. For the drill rig, it's referred to as a diesel, also a diesel electric, if that's what you meant by hybrid. It is a diesel power generation of electricity. The actual rig runs on electricity, but it's a diesel generation on location generating that electricity for the rig.
Got you. And why diesel instead of CNG?
So in our situation, we are very remote and do not have a good supply of CNG for the rig. And also with rig availability, we can't guarantee that that's necessarily going to be an option for our location. I can let Nate explain that a little bit more if needed.
No, that's good enough. Thank you for the response. And in Ms. Wazelinski's closing statements, and Commissioner McGowan touched on this as well, I thought I heard her definitively state that without creation of the sumac pad, that you would not develop the eastern half of the unit. So if you were restricted to the Grinberg pad, you have already made the decision that you would just simply not develop the eastern side of the unit. Is that correct? Can you confirm?
That is correct. That would be more of a reach out with the directional drilling and step out complexity than we are comfortable with.
And so your plan would include just not developing at all that eastern side.
It would honestly include a proposal of additional well pads to develop the eastern side.
Thank you. I appreciate that. And Mr. Chair, if I might, since I agree that I think we're moving toward, and you can put that slide down. Thanks for pulling that up. I really appreciate it. If I might, since I think we are, and I would agree with moving towards an executive session to talk about the issue of correlative rights and underdevelopment, I think we definitely need more discussion on that point alone on this application. But I would be remiss if I didn't state a little bit some of my concerns associated with the sumac pad, because if we do back off for future consideration, I want the applicant to be aware of where I sit there. And so if you'll indulge me, I would normally hold these for deliberative comments, but I do think it's important to point out, as Commissioner Messner has, that this is significant, additional disturbance. We're talking about, an 8-acre pad and nearly a half mile of road to get into that pad, whereas the other pads are built and right next to the county road. And the maps that we looked at as part of this presentation were intentionally plat maps. I'm not suggesting that there was some intention to hide anything, but we didn't see a topography map as part of this presentation. And essentially, it is largely undisturbed east of the Grinberg pad up into the minor canyon country that's up there. And so essentially what this would do is push the entirety of this disturbed development to the east, and along with all the associated buffers for wildlife as well. As Commissioner Messner pointed out, CPW, and even as he mentioned, is bolded in their statement that they do prefer existing locations. I noted in the presentation that a different part of that was bolded for illustrative purposes, but that's not the part that was bolded in CPW's. And I believe that CPW put this forth as a but if not type of scenario, which is what we've asked of others in the past, that give us your preferred alternative, but if you can't have that, what's the fallback? And as Mr. Moret talked about, they're not, experts on downhole technologies or anything like that. And so it behooves them to give the but if not scenario. I think it's upon us, the commission, to decide whether this appropriately avoids, minimizes, and mitigates and follows the mitigation hierarchy. We heard in the presentation a lot that is the most avoided method. In my professional opinion, it's not. It pushes everything to the east. And we're talking about not just the creation of the pad and the drilling, but we're talking about 10 to 12 trucks per day for a period of multiple years, which eventually is down to 2 or 3. After a few years, there's much less disturbance if that truck traffic is restricted to the existing county road where the Greenberg pad is. So it is a significant additional disturbance that, in my opinion, is avoidable technologically. And so I think it's important for this operator to hear that that's my current thought on the whether this is compliant with the mitigation hierarchy. So I'm not looking for a response at this point on that, and appreciate your responses to my comment. But with that, Mr. Director, or Mr. Chair, excuse me, I also don't know that we're ready to make a decision without further discussion on the correlative rights issue.
Okay, great. Further commissioner questions, Commissioner Cross?
Thank you, Mr. Chair, and thank you for the presentation. I want to try and clarify a few things as I've been going through this. First of all, and I think you were about on slide 8, and we don't necessarily need to bring up the slide right now, but it was showing the True Ranches LLC ownership of the surface in different areas. And I think at about that time, in my notes, I have that you said part of what the owner said in terms of wanting this additional pad was based on future development plans and how to do that development. I'm first of all wondering, is this future development plan with CCRP, with other operators and True Ranches, do you know the details of the future development plan?
Yes, Commissioner. So I don't think if I said plan, I misspoke in that it was developed, just yet to be developed spacing units. And so both running east on the Colorado side and to the north on the Wyoming side. And so Wyoming, if we look at the data for Wyoming, there's a lot of 4 wells per DSU that have been drilled and being permitted, just on the other side of the border. And that's where they wanted to make sure, well, if we're doing this, we don't want to strand minerals. If we're too far to the west using a Grinberg location, then what happens on the east? If we have too much of a step out when we're building curve, what happens to the little portion that's left behind that we're not completing on the north end of the DSU? So that was part of that discussion, was to ensure that we are going to develop the minerals as best we can, similar to why the Grinberg pad is south a little ways. We don't like that with the directional step out, but also we have to back build to the north in order to get to the very end of the DSU before we break and head south. Whereas the sumac pad is placed on the very north side of the DSU, so we have the full lateral length to develop.
And I will get into some of the questions about some of the step outs and the direction with that. I guess what I'm trying to understand, first of all, is based on what you just said there, this kind of goes back to what Commissioner McGowan was saying as well. Are there anticipated DSUs to the east as well?
Not for CCRP.
Are there anticipated future DSUs to the north of this site?
To the north for Wyoming, yes, there are DSUs that are being actively developed right now. Again, not by CCRP.
Directly to the north, or is this within the True Ranches LLC surface ownership?
It would be on the True Ranches LLC surface ownership. And I'm looking at a map, it would be north to the DSU and then one over, so to the northwest adjacent DSU.
Okay. And again, part of the reason I'm trying to understand this is because what I understood your testimony to be is the True Ranch LLC wanted the sumac pad as part of that future development of DSUs. And so I'm just a little unsure how the location of the sumac is applicable to future DSUs.
I think that was a misunderstanding. It is not for future DSUs. It would be for this one DSU only.
But True Ranches, not just CCRP, but True Ranches is also supporting the use of the sumac pad.
Yes.
And so I guess if you could clarify, what is the basis of them wanting to use the sumac pad?
So my understanding where they're coming from is to get to the east side of the sumac DSU. So in the same DSU lands that are part of this application, by having this well pad located there, we can efficiently develop the full DSU, including the east side of this DSU, rather than having a longer step out with less efficient development and production on the eastern side of the DSU, which leads towards better development on offsetting DSUs both to the east and to the north.
Okay, and I think this also ties into what Commissioner Messner asked as well. And one of the things that I wanted to touch on is the surface owners and more ideally the mineral owners here, their understanding of this, we'll call it at odds testimony. And I'm going to get into the testimony here in a minute, but this at odds testimony of the ability to do this. So based on what I'm hearing you say, True Ranches at least is understanding that there could be potential minerals not efficiently developed based on step outs and everything else. But earlier, kind of what I understood is, well, we just presented everything that was presented to the commission, but nobody complained. And so I really want to try and understand if the mineral owners were made aware that there is this conflicting testimony. Not just that, they had an opportunity to talk about it and nobody questioned, Nobody complained, but whether they're aware that, potential step out issues that you've identified mean that there could be minerals left in the ground. Potential density issues mean there could be minerals left in the ground. Have they been made aware of that outside of what was just presented to them? And I guess to clarify at the very end of that, because it sounds like you've at least talked to True about the fact that there could be step out issues and there could be minerals left. But
Yeah,
I'll
I'll answer part of that question. I think Kelsey might have to grab some of that too. But so True Ranch, it's conversation. It's not an official notice that was sent out. And I think when Kelsey was responding to the other question, those are official notices through the procedure. With True Ranches, that's conversation on location while we're siting the pad. And for True Ranches, they are not a mineral owner in this DSU. They own minerals adjacent to the DSU. Whereas when we're noticing, I believe the notices were to owners inside the DSU. In addition to that, with True Ranch, that was part of the conversation as to where to locate the sumac pad. We do not anticipate leaving minerals behind or stranded with the sumac pad. And that's why we agreed on that location. We did not notice them nor anyone else as far as if the pad was moved somewhere else, there might be minerals left behind. The notice was for our proposed action of the sumac pad.
Okay, so before we get to Ms. Wazelinski expounding on that, I want to make sure I understand. True Ranch has none of the mineral ownership here, but True Ranch wanted to make sure that the sumac was used, so there was the ability to develop the easternmost part of this DSU.
Correct.
Even though they have no mineral interests in this DSU.
That's correct.
Okay.
Thank you, Commissioner Cross. And I'll just expand a little bit on the notice here. So as Jesse stated, the notice for the sumac was the proposed development plan of sumac. So not kind of the what if scenario. If we were to use alternatives 1 or 2, what would that step out look like? And again, all of the leasehold interest owners and unleased owners received notice of that full application, the OGDP, including the spacing. And it's up to those mineral owners to act on that notice. And if they had a concern on harm to their correlative rights or waste, they had several opportunities to speak up on that. So, while True Ranches is the clearly majority surface owner in this area and did agree specifically that sumac location could be located there with a signed surface use agreement, True Ranches owns minerals in the area, not under the unit that we're proposing, CCRP is proposing, but in the area. So they certainly have an interest not only for the efficient use of their surface, but the surrounding mineral development acreage. And I think that's what kind of we're getting at here is when you look at this holistically, not only in Colorado, but in Wyoming, what's the most efficient development plan? And that's why the sumac pad would be supported.
And so I guess to build on that, to the extent that True Ranch is looking at an efficient development kind of in the area, and as Mr. Martin said, not necessarily from CCRP, I'm curious as to how specifically the sumac pad being chosen for this development of the DSU, how this well pad in this DSU is going to be applicable to the efficient development of True Ranch minerals in other DSUs.
And I'm happy to address part of that. And I see where you're going and where the confusion is. Again, CCRP can't speak for other operators in adjacent units and how they're developing their acreage, but the sumac pad will fully efficiently develop the proposed unit, 1,300 acres of minerals. If the sumac pad were not to be used and CCRP were to utilize potentially one of the alternatives, if even feasible, in order to fully develop CCRP and every other mineral owner's interest in that unit, they would likely need to put another pad on the surface to get to the eastern side. And I think that's the point is the surface owner is trying, has 2 interests, subsurface and surface. And so, looking at the development, and again, we're not here to speak about other operators adjacent to this unit. But looking at this holistically, and then particularly looking at the sumac pad, it will fully develop the unit that CCRP is proposing. And that will protect the mineral owners within the unit. You know, and arguably, if the sumac pad is not utilized, there will be waste and there will be harm to correlative rights, because it's a high likelihood that the eastern half of the unit may not be developed. If it is, it's from another surface location, which is another impact in high priority habitat. So there's a lot to consider here. What's before you today is an OGDP for 1 new pad, 3 new wells off that pad. You know, the True Ranch will have one permit coming off of that pad for 4 total in the unit. And, you know, we've done a robust analysis that development plan is protective of correlative rights and avoid wastes and complies with the act.
As I get ready to move to some of the geology testimony, I want to first make sure that I'm clear on this. There's the True Ranch pad, and there's also the Greinberg pad. Now, I know there's some discussion of potentially using the Greinberg as saltwater injection and things like that, but one of them has been drilled but not completed. Which well has been drilled but not completed?
Greinberg.
And it's a horizontal well that's following where the True Ranch is proposed to being drilled, or what is the direction of that well?
I believe that was permitted as a 1 mile horizontal well, but it has not been completed.
I can answer that question. Right now, it's just a vertical casing. There is no horizontal leg to that well.
And how deep is the vertical casing on that?
I can answer that. It's a vertical well. It was permitted as a J-stand well. Surface casing is set at 2370. And then the 7-inch production casing, again, vertical is set at 9258. Codell in that area where we're at is 8547. So casing is set about 700 feet deeper than the Codell.
Okay, thank you. And so I want to try and understand a little bit going into the geology aspect of this. And I think I heard you say during your testimony that you're going into the Codell and Niobrara, but not going into the Carlisle and Hayes. Is that correct? Or producing from, not necessarily going into, but am I understanding that correctly?
I will let the CCRP team confirm this, but we often space all 4 formations in order to, if there is deviation into a non-target formation, it's spaced in the unit. And so I'll let Nate or Jesse talk to the target formations here, but you'll commonly see 4 or more formations spaced. Several of those may just not be target, but they're spaced in order to prevent a violation if there's unintended deviation into another formation. So Nate or Jesse, I don't know if you can speak to the target formations here.
Nate, are you comfortable taking that one?
Yeah, I mean, target formation here for us is the Codell. So that's what all these wells would be. The Niobrara is just thinned out in this area a little bit. So we don't see big development on the Niobrara.
Because I think I remember reading in your geologist testimony that it was like 16 feet for the Niobrara. Is that correct?
Yeah, I don't remember what that is.
And so part of the reason I wanted to go into the geology testimony, and I'm glad Ms. Burns is here as well, is again trying to understand this kind of discrepancy. And having done stuff in Wyoming, I do recognize that there's oftentimes 4 wells per DSU used there, but I'm trying to find in the testimony where it is confirmed that your geologist thinks that 4 wells will be sufficient to develop this entire DSU. And
Commissioner Cross. Oh,
if you can point it out to me, maybe that's helpful. But because when I was looking through a lot of it, I was looking through the testimony and it was talking about these different areas of the DJ, those formations being present and continuous, but I wasn't seeing anything about the ability to actually develop those minerals.
Thank you, Commissioner Cross. And I believe you'll find a deeper evaluation of that in the engineering testimony, which was also prepared by Petrotech. And I do have it up here. You know, if you look at the target of the Codell formation, being the planned development, there's an analysis looking at analog wells of what that average drainage acres per well is. And the intent, again, of engineering testimony is to show that the proposed development will not drain outside of the requested unit boundaries. And here it meets that threshold. So each Codell well, I believe, is anticipated to drain approximately 133 acres per well, which totals 532, which will not overdrain the resource. When you look again at what's developed in this area in the Codell, you know, when you consider spacing of wells and efficient development, that number 4 is a very common number to efficiently develop the unit.
So the 500 acres, we'll say approximately 500 acres within the 1,300 acre DSU.
Correct. And, you know, at least from my experience, I've reviewed a lot of engineering testimony. It is very common to see acreages based on analog wells to be far smaller in the engineering testimony than the requested unit acreage. And again, it would be a violation of the Oil and Gas Act to overdrain a unit that would cause waste and harm to correlative rights. So here the engineering testimony is supporting you know, a number of wells that won't lead to unnecessary wells and will sufficiently protect correlative rights. And again, you know, it is also common that when operators develop an area, if this is not efficient, it's in CCRP's best interest to come back and drill more wells. So while we can talk about, you know, wildlife stipulations and avoidance measures there, nothing prohibits an applicant to amend an OGDP and amend a spacing unit to increase density.
And fully understand that, and that's something I want to touch on in a little bit here. But I guess for the non-engineers in the room, could we maybe, instead of talking about acres, get an idea of the drainage with respect to feet, so we're understanding kind of where everything is going in that?
Yes, and that's a good question. And you know, my mind sort of does easily go to acres because I look at a unit size and multiply number of wells times average acres. Is it less than your requested unit? And you know, we could dive in further into the engineering testimony, again prepared by Petrotech, but it does contain, you know, some half-length calculations to support the requested subsurface setbacks, with each half-length being 231 feet. So the well would expand out 231 feet.
And that's the radius, not the diameter.
I'm not an engineer, so I apologize for taking a lawyer approach on this testimony.
Not a problem. And maybe here in a minute, it might be helpful to have Ms. Burns or Ms. Trask speak to this as they deal with it more often. But the 231 feet is the radius, correct? Not the diameter that we're talking about with the spread for those?
It's the fracture wing is what it's called in the engineering testimony.
Okay. And I do notice that Ms. Trask and Ms. Burns are on video here, and so I don't know if they maybe want to provide a little bit of.
I think they do. So if we could allow Ms. Trask to provide commentary, that would be helpful.
I appreciate the opportunity. I wanted to give maybe a little more insight as to some of our concerns, and I won't speak on behalf of our engineering manager, Diana Byrne. She's welcome to correct me if I misspeak here. In reading the engineering testimony provided with this application, in Exhibit E4 discussing drainage schematics, the applicant notes that as Ms. Wazelinski also mentioned, the Codell, Fort Hays, Carlisle fracture wing consistent with desired development is consistent with a length of 231 feet. So again, assuming if that's the drainage radius per well, I'm a bit of a visual thinker. And so if I think of a well bore, we'll just orient it visually this way. And so that when that well bore is completed, the drainage radius of that well bore will reach outward in this direction and this direction, three-dimensionally, out to approximately 231 feet. If there are 4 wells in this DSU, and each of those wells is only draining sort of think of it like a tube of drainage. If each of those 4 wells is only draining a 231 foot wide tube, there's a lot of space in between those 4 well bores where the minerals are not being drained. This to me fundamentally speaks to our concerns about underdevelopment. There will be significant minerals stranded in between each of those 4 well bores. And so staff's concern about this underdevelopment is that if there were, say, hypothetically 8 wells proposed in this OGDP, that would more effectively reach those minerals and minimize the amount of minerals that would be stranded, given a 231 foot drainage radius as described in this engineering testimony. And so our concern is that the engineering testimony does not support CCRP's conclusion that this development is full and is efficient and is effective.
Ms. Byrne, do you desire to add anything further relevant to staff's consideration here?
No, Sabrina has definitely tackled what the concerns are. That if you, we feel like the density provided with the science that's to back up the desired spacing, that they don't align. And no, Sabrina's got it.
Great, thank you. Further questions from commissioners for the panel? Commissioner Cross.
Thank you. And I think one of the, oh, I'm sorry, I've got a dog howling over here. Just a second.
Ms. Wazelinski, while we're waiting for Commissioner Cross's dog to stop yowling, would you like to provide some additional information? I saw you raised your hand.
I did. Thank you. Just a brief comment. Petrotech is the company who did the engineering testimony and has extensive expertise, obviously, and submitted sworn testimony and support. And so if it would benefit the commission, we're happy to have a Petrotech representative explain the engineering testimony, whether that may be difficult today, but if we're considering an executive session, we would be happy to pull up a Petrotech engineer to provide insight as to their sworn testimony.
Okay, thank you for that. Commissioner Cross, are you able to unmute without a yowling dog?
I believe so, and I apologize for that. My wife is taking them one by one for walks, and I think one of them was upset that it was not his turn. So I wanted to quickly also touch on, sorry, he's still going a little bit. I just quickly wanted to touch on a little bit here with respect to the testimony given by Mr. and I apologize if I massacre your name, Krzyzewski, with respect to the constraints on the step outs. And so I think it may be helpful here to pull up the slides, and it was slide 13 that we were looking at. And I think maybe one way to start here is in looking at these step outs, we're looking at wellbore A and wellbore B. And I guess to confirm to begin with, is it A, B, C, D going from left to right or west to east? Is it the ones from the sumac or ABC and the true well is D? I guess just to make sure I understand how that process is, how this is set up.
Yeah, what you're looking at here are 2 existing CCRP wells put up here for illustrative purposes to show that we've got some empirical data that supports the argument. These 2 wells are existing producers that are in our closest active DSU 4 miles to the east.
And these are from the same pad, or are these from different pads?
Correct, same pad, same surface location, and yep.
Okay, And one thing I want to double check here as we're looking at this, could you explain the colors? We have the green, the yellow, the red. Could you explain what those are signifying?
The green, yellow, red is just from this modeling software program that just has a cutoff based on color, which is indicative of basically dogleg severity. So dogleg severity is just how much the well is bendy, put it in layman's terms. So obviously green is good, red's bad.
Okay. And so one of the things I wanted to check here is, so you have done, you find that the 3.3 per year is to the extent that you would not be willing to do the easternmost well within this DSU if you use, for example, the Greinberg location. Is that correct?
It's not the only reason. It's one reason that a large step out is problematic for us for the life of the well. You know, these well bores, once they're drilled like this, I can't change the shape of them. And, you know, if I put similar technology in both wells, I'm still always going to see in wellbore A that it's going to fail twice as much. And even if I put better technology in wellbore A, it's still going to fail more. There's just something with the geometry that is fixed and problematic for the life of the well. But that's only one issue on the production side.
Okay, and I know you also talked about the fact that as you're doing the turns and you're drilling, you're also potentially missing some of the steps. Is this specifically with the Niobrara that you're worried about missing the formation as you're doing these turns?
It's with the Codell in this case, but yes, what happens is when you're drilling a complex shape like this, it's more difficult to stay on path when you're drilling. There's more torque and drag because basically, you know, it's like the hypotenuse, right? The hypotenuse is longer. It's a longer well path to drill. And you've got less drill bit control as you're going out there. And so as you're making that turn, which is kind of the red portion of that well, you know, there's a greater chance that you're going to have less control around there and be steering up and down to try to land in formation. So you could be slightly above or below target coming in there. And, you know, what that means is instead of the lateral being the full 10,000 feet in formation, you might only be 9,900 feet or 9,800 feet in formation. Also, while you're making those turns and trying to steer that down there, the wellbore shape itself ends up being a little more swirly, which can cause problems on the production side again. So the cumulative effect is greater chance of being slightly out of formation for the entire length of lateral and a swirlier looking wellbore.
And fully understand and appreciate some of the, especially as you said, not necessarily technically feasible, but economically feasible. Could you maybe put into perspective for everyone to understand? So a 1.5 failure rate per year versus a 3.3 failure rate per year, you're looking at double, but it's still not an overly high number. Can you provide some kind of context as to economically how this is impacting you and why that failure rate is so significant? And I guess maybe to frame the question a little bit is sometimes we see applications come before us and they're looking at a DSU that's developing 4 different sections. And the idea is in this one, you're on the north, so we'll talk about it being north. They'll put it as far north as they can. Maybe they have to do the directional up and then back to the south, but they're putting it kind of in the middle of those 4, and they're stepping out the entire section. So a mile step out to each side before doing the 2 miles down, and in some cases even 3 miles down. And they also speak to potential issues with failure rates there as well. But I guess I want to understand with that, you know, as it becomes an economically feasible and potential issues, if you could kind of put that in perspective.
Yeah, I won't get into the economics. I don't want to hear to debate that, but it's very real and practical, and it also touches on the density question as well. Obviously, when these wells are new, they can tolerate 3.3 failures a year, right? That's not the problem. Certainly, you guys know that. It's as you look later in the well's life, right? These wells Codell, Niobrara wells, wells in the BJ Basin come on strong as they do with most unconventionals, but then, a few years down the road, they've tapered off significantly. And then when you look at the ultimate recovery of that well near the end, right, you're not producing very much per day. Now, at the same time, if you're still suffering quite a few failures, that cost doesn't care how much the well is making for the most part. You're still going to have expensive failures to deal with. So what that means is you reach the economic threshold potentially sooner. CCRP certainly, as with all operators, right, we do this to make money, and if a well becomes uneconomic, then at a certain point it goes on the P&A list, right? And if you have too many failures and the well is too expensive, you end up basically P&A-ing that well sooner than if the well was very economic and didn't fail and was able to support itself for longer, which means potentially you recover more minerals for the life of the well. So practically speaking, we can't totally ignore economics. And the well density piece factors in as well, because if you have a well that's in a unit that's overdeveloped and the wells don't make as much from the wellbore, then certainly they're going to reach their economic threshold sooner. And the engineering testimony that was brought up is one way of looking at it, right? It's a model. Practically speaking, as an operator, right, we don't just look at drainage radius because that's a modeled number, and as you guys know, the DJ Basin is highly fractured as well, which factors in. But we also look at actual well results in the area. There's nothing better, and the actual well results in this area would suggest that performance at 1,300-foot spacing is quite a bit poorer than individual well performance on 2,600-foot spacing. Indicating there's some well interference that exists at that 1,300-foot spacing, which to the same point ultimately means you could reach your economic threshold sooner. So that's a very important thing that we obviously look at, all operators look at, is what's the offset well performance look like, apples to apples.
Thank you. I appreciate that. And I feel like it's always helpful to kind of frame not just that it is more difficult technologically, but also kind of how that plays in. And I think the one other thing that I want to try and touch on here, and I'm just going through my notes here quickly, is trying to understand when looking at some of the conditions of approval that have been put forth by staff. I think you said for the Greinberg, it would either be plugged and abandoned and reclaimed, or it would be used as an injection well. What's kind of forming the basis of that decision at this point in time as to whether it will be P&A'd versus an injection well? Maybe why are you not using the Greinberg for that westernmost well within the spacing unit? Kind of explain why the Greinberg and the True and why those are being proposed for those uses.
I can talk to the timing of that decision. I don't know, Jesse or Kelsey, if you want to address the second half of that question, but the conversion to an injection well makes a lot more sense for us if we've got development in that area right now. Currently, we only have 2 wells, or actually, really one well, the True Ranch V502 that's producing. And so if we ended up developing wells in the area, it certainly makes a lot more sense for us to look at converting that into an SWD. If we only have 1 well in the area, right, that doesn't make as much sense to us to build all the infrastructure and jump through the hoops and put a facility out there, right, for 1 well's worth of water. So kind of a chicken and egg thing with respect. It doesn't make sense to do the SWD.
I can answer the other question there. So the other well drilling on the west side of the Sumac DSU is coming off the True Ranch pad. We have a producing well there. We already have infrastructure for power and for midstream. And so that's why we want to utilize that pad versus trying to drill an additional well off the Grinberg pad.
I think those are the only questions I have at this point in time, Mr. Chair. I would say that I know other commissioners are in favor of an executive session. I'd be fine with going into executive session. I also think, at least from my perspective, it would be helpful to talk with their engineer who put forward this testimony to try and understand that a little bit better, and we can kind of delve into the discrepancy or differing points of view.
Okay, thank you, Commissioner Cross. Ms. Wozlinski, with regard to getting your engineer to testify, I believe they're not available today. Is that right?
I don't believe so, Chair Robbins, but we could definitely schedule for next Wednesday if that date is available.
Okay, thank you for that information. Commissioners, what are folks' thoughts? I'm somewhat of the opinion that if we're interested in hearing from the engineering testimony, and we're also interested in doing an executive session, that perhaps it makes sense just to continue the matter for a week. And in the interim, we can have an executive session on the issues that have been raised, and then take this matter up first on our docket next week. That's just one commissioner's thoughts about it. What are other people thinking? Commissioner Messner?
Thank you, Mr. Chair. I would concur with that. I think it's important to hear from the engineer's testimony. I think it's important for us to have an executive session. I think it's important for the applicant to consider some of the questions or comments that were brought up today in regards to their proposal. And so I think next Wednesday makes sense.
Okay. With that being the case, and not to try to move this forward, but do we have a motion to continue docket 2011 2206 00164 to next Wednesday, February 8th, to be considered first on our agenda at that time?
Could I maybe ask one quick question that I apologize, I missed in my notes here before we make a motion?
Yes.
And my question was, I believe that you said that there was already a surface use agreement with the surface owner for use of the sumac. Have they provided any kind of indication of not being able to do any kind of surface use if you were to use the Grinberg, or if you were to go further out and ultimately not construct the sumac pad? Have they expressed any problems with use of the service if that's the case?
To answer that question, we did not specifically say, well, if we don't go here, can we go somewhere else? That was not asked. It was just agreed upon this was the best location.
Okay, just wanted to double check. Thank you. That said, I'd make a motion to continue until next week.
Second.
All right, motion and a second. Further discussion? All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Okay, Ms. Wozlinski, the motion to continue has passed. We would encourage you to bring the engineer for additional, so we've not closed the record, and we'll look forward to hearing from the consulting engineer with regard to this, these questions that have been articulated here today. And I want to thank you and your client for participating today. No adjudication has been made. We're just trying to get to the bottom of some interesting questions that are a little bit novel for us. So thank you very much.
Thank you, Chair. Thank you, Commissioners. If I may ask one question, we may
Go ahead.
have some demonstrative exhibits, particularly on the engineering analysis, that may benefit the discussion. So sort of just thinking on the fly here, would you be amenable to that if we were to submit a PowerPoint ahead of that hearing date?
Absolutely. We love PowerPoints. Seeing things on a piece of paper is very, very helpful. If you want to send it in ahead of time, that'd be great too. And obviously share it with Ms. Trask and Ms. Byrne as well.
Sure, absolutely. We'll upload that into e-filing so it can be publicly viewed.
Great. Okay. Commissioners, I think at this point, we should, I don't think we need to do anything other than just sort of like note for the record that our next matter is teed up for 2 p.m. today. That is the KPK matter. And so with that, I guess I would just suggest that we take a break, everybody get lunch, go for a walk outside, refresh yourselves, and we will return at 2 p.m. to take up the KPK matter, and that would be the deliberations by commissioners on that matter. All right, see everybody in a bit.